My lord, may I be permitted to mention one matter?
Yes.
This is a 2014 matter. It's an insurance matter. Let it come up to your lordship.
You are appearing on behalf of the
Insurance company.
insurance company. Which for the claimant, do you know?
No, my lord, not which is the execution
But-
proceed.
Execution proceeding is pending
Yes,
before the learned
court below.
court below. So you are the appellant.
I'm the appellate.
Yeah.
Right. আজকে কত তারিখ রে?
May I beg to mention it's wrongly written and now corrected.
What?
That's it, application for correction.
Okay. No, only application is not required. Is there is any correction or
That's
No.
name should.
okay, name be correction. I think the order correction.
Application not for it's a modification of the loss.
Okay.
My lord, I'm also mentioning other two matters. One is on behalf of the claimant. So lordship is they're tremendously suffering for of money, my lord. That's why I'm mentioning.
See, I'm for the claimant respondent, Lordship. Lordship, though this is the observation part, Lordship, it is written the awarded a sum of rupees 9,26,000.
Yes.
That is the interest part for the delay payment that has been omitted. If it is not there, Lordship, the tribunal will create a problem. Second page, Lordship, upper portion, first line. Delay payment for this 6% interest for delay payment that has been
You are referring
page
Page-
number
page number
2.
of order dated 8th of
Yes,
August.
that is the final order, Lordship. 8 August.
8th of August. And you are referring paragraph.
Second page, first line, though this is the observation part of the Lordship, that the awarded a sum of 9,26,000, but the interest part for the delay payment 6% that has been omitted.
It is FMA 75.
Yes, 75.
What order is referring? Page 2. Give me your papers.
75 of 2000. This is the
Make it underlined.
order.
Okay. Server copy is otherwise. Okay.
Only so interest part.
I have this line in the first page. That's why. So the learned tribunal has awarded a sum of rupees 9 lakh in favor of the claimant.
Only interest part is not there.
with interest.
Interest 6% was 6%
So learned
for
tribunal
the
has awarded interest.
interest.
So what is the final order? Only direction to recover the.
Yes. But interest part is not there. If in the observation part, the tribunal will create the problem, Lordship.
It's the order of the tribunal.
Yes, order of the tribunal is there,
Very
but the interest part, if Lordship observation, it is not reflected. That it may be a problem of the claimant, Lordship.
Just wait, let me. It is the order.
6% for delay payment.
%6 per annum from the date of filing of the claim application.
For the delay payment.
For the
delay payment, it is written there.
delay payment. What are you saying?
That is the delay payment means It is calculated from the date of the filing of the application.
That is the order.
That is the order.
So what is the delay payment? No, no, the simple 6% interest is given.
Yes,
Only that term can be added.
yes, yes, yes.
Very well, please take down. In the last line, after, in the last line of order dated 8/8/2023, the matter is appeared for correction. In the last line in the order dated 8th of August 2023, after the sum of rupees 9,26,000, the under mentioned clause should be written. Under mentioned clause would be written. Stop. Along with 6% interest per annum from the date of filing of the claim application, that is from January 4th, 2010. The department is directed to make out the correction. No. That is the order. The instant order passed by the instant order, we made a part of the order dated 8th of August 2020.
Grateful, Lord.
Number 3. Number 4. 5.
4.
Because the respondent claimant Mr. Sahib Mujumdar appears for the appellate.
Yes. Where is Mr. Shah Mujumdar? You are for the,
I'm for the added respondent.
today is fixed for hearing. And you are
Lordship, I am
supposed
filing
to
an
file one,
supplementary affidavit.
supposed to file one supplementary affidavit.
Yes, Lordship, I am
Have you
filing.
served upon the insurance
I
company?
have, sir.
I have issued.
You also received.
Pass over.
Okay, pass on. You just wait. Next.
Number 5. Like what's on? Read the matter.
Not to this week.
Not this.
Not this week.
Number 6. 7. 8. 9. 10. I have for the appeal not Mr. P. Chakraborty from the insurance company.
Who is for the insurance company?
Mr. M.P. Chakraborty, Matanda Pradap Chakraborty.
Okay.
I'm for the insurance company. Let the matter be only not today, Lord. Paperwork is ready. We shall start today. The matter may be taken up.
What is the dispute? Why you
Award is passed on the owner.
upon the owner?
Owner. I shall pay for recovery of the payment and
So
recovery.
you don't have any other claim,
No other.
only
Only enhancement is there.
then if the
So-
enhancement is not there, I can dispose of it now. Enhancement is
Yes,
there.
judge has claim 15,000
163.
163.
163.
3,000 and 15,000.
They will come on tomorrow,
Only I shall come tomorrow.
not today.
I'm grateful.
Number 11.
Page 30. Page 15. 17 and 18.
But it's in Article 15.
You are the appellant.
I'm the applicant, but here not I find some discrepancies. Skopa Mukherjee appears for the insurance company. Not look to the paper. Now this appeal notes in connection with MSC case number 259 of 2010. Okay. My lordship have looked to the certified copy of the claim application. The top this of MSC is 259 2010.
259 of 2011.
Right. This is the dispute. In the award, my lord, in the certified copy, my lord, it has been wrongly typed as 2011. I have filed the appeal on this 259 2011. Now, when I prepared the paper book and looked all the certified copies, my lord, it is noticed from the last certified copy of the claim petition, first page of the paper book.
$259 of 2010.
10, and there are all the papers, evidences, and all the papers, it is shown as 259 of 10.
Yes. Court fees,
Everything.
everything is there on 25th of August 2010.
Everything. But this appeal lot is still no FMA number. It is FMD number. The appeal of 2012. But here, what I did, some clarification is required. We also call for the records of 259 2010. Then it will be clear. In the record also, in the tribunal's record also, there is mistake.
No. So this is the noting of the registered administration.
Right.
Regarding the defect. This is the defect.
What
The defect is that the Vokalatnama has been executed on behalf of the minor appellant number. That is the defect.
has not been executed.
Yes, you have submitted the Vokalatnama on behalf of minor also. That means minor has to be represented.
So repeat.
No representation is there. This is the defect. And this is not a defect.
Probably they attend majority.
Whatever issue, you have mentioned the name of the appellant number 2 as minor. And you filed the Vokalatnama on behalf of the minor also. Without representing. This is the defect.
That will be corrected. Will also,
So you correct it.
I shall correct it. It will also leave below, I shall correct it. But what shall be the remedy of this?
Now whether you have called for the LCR,
The records has not been called for.
then you correct the memo of the cause title of the appeal. What is the memo?
Memo will not,
You first correct the memo of the cause title of the appeal. Dissatisfied with the yes, 2011 is there.
11. I have drafted as per the judgment.
However, you correct the same, amend the same, thereafter it would be appear in the list. Please take down. It appears from the report of the on a registered administration that there are some defect in the instant appeal. The appellant is directed to take necessary steps for removal of such defects, but such steps has not been taken. Considering the same, the appellant is directed to remove the defects. Let the matter go out of the list. Parties are at liberty to mention.
Number 17 and 18, 19 and 20, 21, 22, 23, 24, 25, 26, 27, 28 and 29, 30,
Call it.
31 and 32, 33.
The Bonik is there. Lords will pass it over there.
Yes.
34, 35, 36 and 37.
Lords will kindly pass it over.
36 and 37. Mr. Roy is there.
I am also there, but why?
Whether order is there to call for the city. So one. CD one state advocate has to be there to produce the CD. CD has reached to the score. CD has reached, but one state advocate has to be appeared with the CD. So let it pass it over. Let them come. Next.
38, 39, 40, 41, 42, 43 and 44, 45.
45 lordship, I am for the appellant. Unless it's 2-3 occasions matter was called on. I don't
Who is
Mr.
for the insurance company?
Mr. Kanak Bandobadhyay appearing for the insurance company lordship. Earlier occasion you also took time and lost please to grant the time and fix the matter for here not this week and this first time is appeared after that.
So what can be done? Let it be taken the first call.
Lordship.
I've called second time.
Lordship.
Yes.
46, 47, 48, and 49, 50, 51.
My lord, I am praying for not to take because my senior is ill and he has been hospitalized. So I am praying not.
Who hospitalized?
Shomolo Ganguly.
You are appearing in the item number
53.
53. Mr. Jayanto Banerjee is the appellant.
Jayanto Banerjee is the appellant. But my senior Shomolo Ganguly.
Shomallo Ganguly.
Yes.
You are appearing on behalf of the state.
He is for the insurance company. Insurance company. Yes, I asked
Okay.
about insurance company.
So this week
Banerjee,
accommodation. This week accommodation. This week accommodation.
This is not this week.
Only
I'm
this
praying
week
for
will be
not-
sufficient or
I
further
am
week?
praying for not this week.
No. Okay, very good. Not this week.
4, 5, 6, 7, 8. Second call. Item number 3.
Mrs. Tata Mukherjee is appearing for the respondent insurance company. But Lordship, I have filed one application. If Lordship desired, that can be disposed of. I believe
What application?
application for Lordship, factum attainment of majority.
Can
Can Lordship.
do.
Lordship, one thing Lordship kindly consider, the applicant number 2 and 3 are the minors. And Lordship, at the time of filing with the claim application, the applicant number 2 name is supplied by the member of the family because he was minor. His name was written as Lordship
Priti Molli.
Preeti Mollik. It should be Lordship Tithi Mollik. And I have annexed the birth certificate also. And also I have annexed one affidavit to that extent, page 8. Tithi
So
Mollik,
you pray for correction of the name
name and attainment majority accordingly.
in respect of
2 and 3.
2 and 3.
2 and 3.
2 and 3 attain majority and the correction name of the 2. Very well. Please take down. Can 2 of 2023. This is an application for amendment of the name of the applicant number 2. And for recording the fact that the appeal number 2 and 3, who were minor at the time of filing the appeal, who were minor at the time filing appeal, became major. Or the learned advocate peruse the application, also peruse the copy of certificate of birth as well as the affidavit shown by the
Appeal number 2.
applicant number 2 before the learned executive magistrate first class Nodia. Considering the same, the prayer for amendment of name of applicant number 2 is allowed. The name of applicant number 2 mentioned in the memo of the cause title of the appeal as within bracket or within invited. Preeti should be read as, should be corrected as Tithi. T-I-T-H-A. Stop. The department is directed to make out the correction, including the noting that the appeal number 2 and 3 became major. Stop. Can 2 is disposed of. Is the matter next week? Next week.
Friday Lordship taken up. That is appearing in the list. Also, all the departments directed to carry to the Lordship's order. Yes, Lordship. Yes.
Is the
Next
matter
Monday. TITHI.
Number 4.
Yes, Mr. Mojumdar. Let me hear out the matter.
Because my learned friend has filed an affidavit.
Yes.
There is a sharp contradiction in what he says. It seems he's caught in between the arms of a dilemma. Will kindly take up his affidavit.
Yes.
So kindly takes para 3 of his affidavit. Here he says that due to financial stringencies, I have sold the said vehicle to one Pupul Das, son of Ashwini Kumar Das, resident of Sukanto Nagar, post office Ravindra Sharoni, PS Bhakti Nagar, district Jalpaiguri, and had executed an agreement for sale on the same date. Since then, I do not know whereabout of the vehicle. He has annexed this one-page agreement for sale deed. Now, my lord will kindly come to para 8 of the same agreement. Here he states that I am not a necessary party in this instant appeal unless and until it is proved that the vehicle bearing number WP739371 is also an offending vehicle and the vicarious liability towards the claimants rests upon me. Now, my lord, I am confused. In 3, he says he has already sold it, so the entire owner shifts to the new. 8, he says, if the court comes to the finding that this vehicle was also involved, then the vicarious liability shifts on.
Yes.
Let him first decide what will he do, accordingly I can take my step. Now, if he sticks to page para 3 of his affidavit, then my lord will kindly give me liberty to make this person party. Otherwise, it's no use. Now, if he sticks to 8 and says that he is ready to willing to contest this appeal, then I'll start my arguments. Now, he has to decide what he will do. This is absolutely per contra statements in his affidavit.
Whatever maybe the statement is there, you have to proceed along with this appeal now.
Now, my lord, then if he says that he
Let
has
him
sold
say
it,
what he want to say.
then he has said he has sold it.
No,
my lord.
his statement is contradictory. Your
Yes.
submission is that. Let him submit his contradictory statement. Let me hear about the appeal first. I understand what is his content. Very well. What is the merit of the appeal?
Now, my lord will kindly take sir. The FIR, which is at page 35 of the paper.
Yes.
My lord, this FIR, as I was also iterating on the last occasion, was lodged rather by one Kheer Prasad Roy, who happens to be the ASI of police. And what he lodges. I, ASI KP Roy of compound Shiliguri PS, do hereby lodge this complaint to the effect that today, 13/11/2008, I was on CS Bank duty from 8 hours to 14 hours. And at about 11:30, while I was on duty at Jalpai More, but the one road, one HR truck number WB736738 going towards Chonkar and a three-wheeler mini dope number WB739371 going towards Chonkar Road, both in rash and negligent driving, made collision. And on such, one person who was in the three-wheeler mini dope bus sustained reverse injury on his chest, and on way to shift him to SD Hospital Shiliguri, he succumbed to his injuries. His name is known to be Raja Shah, son of Santosh Shah of Shukanto Nagar, Loknath Road, being the victim. Therefore, I pray that a specific case may kindly be. So this was an FIR lodged by Kheer Prasad. Now, my lord will kindly come to the Caesar list, which is the very next page. My lord, in the Caesar list also, my lord will find that both the vehicles have been seized.
Yes.
Now, my lord will kindly come to page 40, which is the charge sheet. Here in the charge sheet, my lord, sections 279-304 of IPC has been, the sections have been 279-304 and on both the vehicles. My lord will kindly come
Yes.
to the last portion, which is at page 43. It starts with during investigation. During investigation of the case, on the basis of the statements of the witness and mechanical reports of the vehicles, a prima facie charge under section 279-304A IPC is well established against both the accused drivers.
Yes.
So both of them were driving their respective vehicles dangerously and carelessly.
Yes.
Hereafter, consulting superior officers, I am submitting this charge. So both the vehicles, this is absolutely specific. Now, what my learned friends were submitting on the last occasion is, we don't know what about the status of the criminal code. And my lord, it's fallen from my lord, it's absolutely correct that has got no bearing on this case. Now, my lord, from these two documents, which have never been controverted in the entire trial, these two documents stand in my humble estimation. And if these two documents has not been contradicted by such documents, which makes this honorable court feel that these are not reliable, it is prima facie, ex facie clear that these two vehicles were equally responsible for the accident. Now, since if my lord is with me on this point, that both the vehicles were equally responsible, then the question of joint tortfeasor and composite negligence comes into the picture. My entire appeal is on this preface only, that since both the vehicles were involved and two documents which have not been negated by any contradictory statements or any contradictory evidence that has come up throughout the trial, so my liability is only to the extent of 50%. I am not going into this argument that this honorable court or the trial court ought to have weighed as to whose percentage is more, whose percentage is less. I am agreeing to 50%. And I am saying I am equally responsible, but I cannot be fastened with 100%. Now, my lord, if my lord wants me, I can go through the evidences as well. But since I believe, have already gone, I want to cut short time of this honorable court. My lord, I will rely upon two paragraphs of Kenaya, which is now it's no more res integra, my lord. This is the judgment which is shown again and again to my lord. I will also rely on this, my lord, but I will stick myself to the last two paragraphs of Kenaya.
Yes.
My lord, here, my lord, another point which comes against me in this appeal is why I am more appealed. Because, my lord, here, this question of composite negligence was argued by the learned. And it was categorically argued that I am not responsible for the 100% liability, but the trial court in its wisdom decided not to make the other party, the other vehicle a party. This is where I am suffering. If the trial court had made him a party, after that, it had not passed any order, then the situation was different. Because Kenaya actually contemplates for these situations, but in which there was this issue before the learned trial court, and the learned court in its wisdom chose not to make him a party, relying upon only one statement by one of the alleged witnesses, which my lord I'll
PW2.
My lord?
PW2.
My that is the only thing against that went against. Now, my lord, may I just humbly rely upon these two paragraphs of this Kenaya judgment. It starts, I'll just hand over the copy, my lord. I just got one copy. This is paragraph 20.22.1. This says, in the case of composite negligence, the plaintiff claimant is entitled to sue both or any of the joint tortfeasors and to recover the entire compensation as liability of joint feasors in joint and several. This is settled law.
Yes.
In the case of composite negligence, this is where I join my issue. Apportionment of compensation between two tortfeasors vis-a-vis the plaintiff claimant is not permissible. He can recover his option whole damages from it. In case all the joint tortfeasors have been completed and evidence is sufficient, it is open to the court tribunal to determine inter se extent of composite negligence of the tribes. However, determination of the extent of negligence between the joint tortfeasors is only for the purpose of their inter se liability, so that one may recover the sum from the other after making the whole payment to the plaintiff claimant to the extent it has satisfied the liability of the other. In case both of them have been completed and the apportionment extent of their negligence has been determined by the court tribunal, in the main case, one joint tortfeasor can recover the amount from the other in the execution. Now, my lord, where I am joint, he is not before the trial court. Admittedly, he is not before the trial court. Trial court has not been included. Now he is before my lord. Now, if my lord is of the opinion that yes, he is also liable to pay 50%, then I cannot go and file an execution case because he's not there. I have to file a separate case.
Yes.
So that increases my trouble. I am in more deep waters because now also I don't know who would be the owner. That is also something which I have to fathom. Now, in this precarious situation which I am, I completely surrender myself to my. And I say, my lord, with all due humility, that if he is there and if he is arguing this case, he should be fastened with this liability, more so because in his affidavit, he has not been able to prove that at the time of accident, whether he was the owner or somebody else was the owner, the vehicle was duly insured by the insurance company. And I have also shown through a document when I pleaded his name that at that relevant point of time from the RTO that his vehicle was not insured. Now, in this backdrop, my lord, when he is before my lord and the entire amount is also duly there before the honorable registrar, even if my lord is of the opinion that I should pay my learned senior friend the entire amount, then my lord will not kindly again ask me or direct me to again go and file a new suit, my lord, because that will take ages. This is my humble, this is where I am trying to come. Now, my lord, I understand it's a beneficial legislation, and I am not running away from my liabilities. I am ready to accept my liabilities, but my lord, to what extent? I am only liable to the extent which the law says I am. I cannot be fastened with a liability which ecstasy shows I am. So in that case, my lord, if my lord directs, if my lord is with me after all at the end of this hearing of this appeal, then my lord will kindly direct me, let him withdraw the amount. I have already deposited. But let the rest of the amount be deposited by him in this court so that I can withdraw. Otherwise, again directing me to a different suit, I have to again impede the parties. It will take ages, my lord. And this is after all public exchange. So, and if it's a case that I am entitled to that 50%, my lord, then making me wait for another, say now maybe a decade or so, because after that he may also come up in another. So it will be a multiplicity of litigations. My lord.
No, issue is that,
Yes.
the issue is not so easy as you are arguing.
I understand.
So matter is that, number one, he is claiming that he was not the owner at the
Right.
time of accident.
My lord.
Number two, the only noting in the charge sheet
Yes.
regarding the fact that the matter was in the offending other car, that is a C door,
The mini door. Yes.
mini door,
Yes.
was not insured with the other insurance company. That may not have been true.
No, it may not be.
May not be.
May not be.
So
It may be the
everything
insurance company.
has to be determined,
My lord.
and it is that determination is not within the purview of this court.
Then my lord will kindly remand it, my lord.
No, remand is not sufficient. I can remand it only for considering that issue.
Yes.
only.
Yes. I'll
But
be
the
grateful.
tribunal is also not within the ambit of determine this issue.
No, my lord, the this question was raised with the tribunal. It's
No,
not
no,
that.
tribunal is only to determine the just and proper compensation,
My
and from whom it has to be.
My
It
lord,
has to
this
be done.
situation
issue.
ought not have arisen with all due
No,
humility, my lord. If the learned tribunal had made him a party. This was before, my lord, before the learned tribunal, the learned tribunal's wisdom chose not to make him a party because he relied upon that single evidence of that PW. Discarding these two, if my lord, the tribunal had relied upon these two documents which my lord has, then the situation ought not have arisen. He
No.
would have made a party, he would have come up with all these which is there before my lord now.
This requires separate procedure. Otherwise, it cannot be. This is quasi civil nature. Otherwise,
Then
the
against
nature,
whom shall I proceed, my lord, that there has to be a direction to that
yes,
effect.
against the appropriate person.
So this would be quite vague, my lord. Appropriate person, they'll have to run from
And
pillar
you
to
can-
post
you
to first
can-
determine who is the appropriate person.
You can use his affidavit. You can use his affidavit here at the same
My
time.
lord, then this becomes a very tricky affidavit because once he says, my lord, then kindly
I understand.
kindly
I understand. I have-
308C, my lord, absolutely
I
contradictory
have
statements.
understand. I have understood. That supports you only. That supports you only. Neither the opposite party, neither me, none other the other courts. It supports you only. It supports you only. Otherwise, very well. Yes. Anything you have to say? Yes. What do you want to say?
As per your lordship order dated 21st June 2023, the appellant contention is that he is not only liable to pay the entire award. And the question raised therein that both vehicle are offending vehicle, and the learned tribunal has hold only the vehicle of the appellant, rather insured by the appellant, is the offending vehicle. Lordship, the evidences are on record, and lordship is the adjudicating authority to determine whether the impugned order is legal, right, just, or not. That's my all humble submission.
Very well. Yes, for the claimant.
My case is very clear. It's a case of composite negligence. I filed a claim against all of the insurance company, all of the owner of the vehicle. I already passed is the appellant blood entire amount has been deposited. I have blood to return some amount. So your blood dismiss the appeal and release the amounts in favor of the claimants. They are not suffering. And my appellants will have no remedy. My letter is to prepare is to file a separate proceeding.
That my lord.
But that order is not there. And there is no such finding who are the responsible and what is the percentage is that.
No, that is to determine by
The
the tribunal.
entire 100% has been.
Unless proceeding is started before the tribunal, nothing can be decided.
Give me the Kenny. Kenny. Okay, please take down. The affidavit, supplementary affidavit, filed on behalf of the added respondent. What is the name of the added respondent?
Sontu Das.
Shambhu Das. Santu Das.
Santu Das.
SANTU.
Yes.
Santu Das is taken on record. Stop. The instant appeal has been preferred against the judgment dated 14th of December 2012, passed by the learned judge, Motor Accident Claim Tribunal, Second Court Jalpaiguri, in MSC case number 37 of 2009. Stop. The brief fact of the case is that the present respondent claimants has preferred an application under section 166 of MD Act before the learned tribunal for getting compensation on the ground that their predecessor was died in a road traffic accident due to rash and negligent driving of the driver of the offending vehicle. Stop. The learned tribunal. No, stop. the case of the the manner of the accident as stated in the claim application as follows. Each stated in the claim application as follows. On 13/11/2008 at about 11:30 a.m. while the deceased along with the goods in the vehicle number 73 in the vehicle number WB73 9371 within bracket mini door was proceeding towards Jhankar Mode. Suddenly, an HR truck, EICHER, HR truck bearing number WB736738 dashed the said mini road with rash and negligent driving. As such, the deceased died. The tribunal has proceeded with this case to hear the evidences. After hearing the parties, the learned tribunal has awarded a sum of rupees 12,22,161 towards the claimants in favor of the claimants towards the compensation, and the present appellant being the insurer of the HR truck is directed to pay the compensation. Stop. The insurance company, that is the insurer of the HR truck, has preferred the instant appeal on the ground that the HR truck was not solely liable for the accident. Stop. Expect the learned advocate for the insurance company has placed the FIR, seizure list, and charge sheet, which was started charge sheet of a police case being number Siliguri
And the number is 373 of 2000.
PS case number 373/2008 dated 13/11/2008. It appears from the FIR of the said police case that the said FIR was lodged by the ASI of police, Siliguri police. The FIR disclosed the involvement of both the HR truck and the mini door of the said accident. Stop. It has been stated in the FIR that both the vehicles were running dangerously at the time of accident. The final report of the police was submitted, wherein it is also reflected that both the driver of the vehicles were responsible as they were driving the vehicle dangerously and carelessly. Stop. Charge sheet has been submitted against both the drivers. On citing such materials, learned advocate for the insurance company submits that the ICICI Lombard General Insurance Company, that is the insurer of the HR truck, is not solely liable to pay the compensation. He also submitted for the solely liable to pay the compensation. Stop. During the pendency of the instant appeal, notices were served upon the owner of the mini door. Stop. The owner, namely Santu Das, was represented with a supplementary affidavit. On perusal of the supplementary affidavit, it appears that it is the statement that the mini door was transferred to another person, namely Gokul Das. However, in such affidavit, he made a further statement that he is not the necessary party of the instant appeal unless and until it is proved that the vehicle, that is the mini door, is also involved in the said accident. Stop. The supplementary affidavit appears to be self-contradictory to the stand of the erstwhile owner of the so-called erstwhile owner of the mini door. Being number WB 73/9371. Learned advocate for the insurance company placed the observation of the Honorable Supreme Court passed in Kenai versus CY versus New India Insurance Company Limited, reported in 2000 within bracket 2015 9 SCC 273. Stop. The Honorable Supreme Court has guided a specific principle in respect of composite negligence. Stop. Paragraph 22.1 to paragraph 22.4 of the said citation is set out here as follows. In considering the entire appeal and memo thereof, and also in considering the materials, it appears to me that the argument placed by the learned advocate appearing on behalf of the ICICI Lombard General Insurance Company Limited had substance. Stop. The police paper, which was made exhibited before the learned tribunal, had specifically mentioned the involvement of both the vehicles in the said accident. Consequently, both the vehicles are the joint tort features. Joint tort features. Tort features. And both of them are jointly liable to pay the compensation. Stop. By virtue of the observation of the Honorable Supreme Court in Kenai Sutra, the present respondent being the claimants shall not be harassed much to receive the compensation. It has specifically guided by the Honorable Supreme Court that the percentage of negligence cannot be determined by a tribunal or the appellate court thereof. So the extent of liability has to be determined by any other forum. Stop. At this juncture, the ICICI Lombard General Insurance Company Limited stroke applicant is at liberty to refer a specific proceeding stroke suit before the appropriate court to recover the portion of compensation. Stop. The ICICI, the appellant is also at liberty to use the supplementary affidavit filed by the added respondent before this court in the said proceeding. Stop. Considering the entire aspect, the appeal is hereby disposed of. Stop. It is directed that the it is stop. It appears that the insurance company has already deposited the entire awarded amount with the Office of the Learned Registrar General, High Court, Calcutta. Stop. The present respondents being respondents number 1, 2, 3.
Payments have already withdrawn 50%.
I shall look up a balance of with
Kindly-
accrued interest.
Kindly record that.
Are entitled to get the entire sum of money as deposited by the insurance company. Stop. It further appears that the claimant has already received the 50% of the awarded amount from the Office of the Learned Registrar General, High Court, Calcutta, by the order of this court on the earlier occasion. The claimants are at liberty to receive the rest along with the accrued interest, if any, from the Office of the Learned Registrar General, High Court, Calcutta, within 4 weeks from the date of passing of this order. Stop. The appeal is disposed of with the direction to the appellant to prefer a separate application, stroke proceeding, stroke suit before the appropriate forum to recover the portion of compensation from the owner, stroke occupier, stroke insurer of the other offending vehicle within bracket mini door bearing number WB 73/9371. Appeal is disposed of.
It was only one instance. My lord, if I have been, my lord has been proceeding, only one thing. My lord, if this such proceeding is initiated by the that case it will be disposed of as expeditious. Kindly note this.
I do not know where you are going to
I
prefer
don't
this.
know, my lord, but if at all, my lord will kindly record that
order-
as expeditiously as possible. After all, it's fine. But I-
Order would be vexatious. That order cannot be.
My lord, still it's from honorable
If,
High Court.
if,
High
no,
Court.
if there be any specific order is there, a specific tribunal is there, specific court is there, then the order is required.
I can go for a money suit. That is the best I can do.
Then after filing, you come here, I will pass the order.
I-
That would be better.
My lord, I-
Otherwise, the order would be vexed. No.
I'm
হ্যাঁ, খেয়ে নিতে লাগবে। তো নিচে দেখে আমরা এই যে 22
I'm ready.
Much obliged to you.
for declaration. Yes, Mr. Boni. Who is for the appellant? You are for the appellant.
Palash Mukherjee, my lord, I had talked, my lord, 2 times. Now, my lord, she says that she is coming, my lord, kindly make it pass. I don't know, my lord, আসছে, এসে গেছে, and let me allow to start my case.
You can start your case, otherwise come on tomorrow. That will be, I have called already one time.
Yes, your lordship kindly allow me to place my case.
You can place it, no issue. You can place it. Come on tomorrow, it will be better. But
My lord, my wish is to finish my argument.
what is the issue there?
Issue is learned tribunal awarded the compensation without following any guideline. It's a
Lump sum amount was given.
Yes, it may be say lump sum amount.
but it is a case of 92% permanent disability issued by the medical board. That has been proved by one of the medical doctors. Learned tribunal did not follow 92% disability. Learned tribunal did not use multiplier as per the age of the. Learned tribunal did not, assess, the income into future prospects. And there are 4 or 5, 6 points. Simplicity. Only learned tribunal says 2 lakh is loss of income, 1 lakh pain and suffering, 1 lakh loss of evidence. This is the way the learned tribunal dispute. Very unfortunate, the part of the tribunal.
What your appellant is doing?
At present she became 100% disabled because she lost her hearing. She lost also speaking power. And
Brain injury.
brain injury. Not is she suffering from the neuro problem. Also, she lost her forever speaking power, hearing power, and also other parts. That's why he appeared.
What was the occupation?
Occupation is he is a government contractor. He is a supplying the cement, sand, and cement, sand, and
Contractor or supplier?
he is a supplier. Contractor comes supplier, getting contract and supply.
Any written?
Yes. There is a the income tax documents file. 2 years, the income tax return and also the
Before accident or after accident?
Before accident, after accident. The accident took place in the year 2004. That is the possibly
Give me the papers.
yes. Let Devendra sir. Learned tribunal holds the income this is a 166 proceeding. Now 140 was awarded.
3,75,000.
3,75,000. Total 4 lakh was awarded. Minus 25,000 in 166 proceedings. He received 3,75,000. Now here the victim injured name is Prabhat Mak. Now he was aged about 28 years at the time of accident, and since he lost speaking and hearing, and she became severe injuries, his father represented him before the tribunal. Father's name is Gangadhar Mak. Now the date of accident, you lordship kindly noted, date of accident was 10 December 2003.
Yes.
Now the offending victim is the bus. Bearing number is Odisha bus. OR 0980215. He was going on NH 6 near Kolaikunda front gate. At that time, the bus came from behind and dashed the motorcyclist, the victim. And as a consequence, he fell down and he got multiple injuries, and he was brought to the hospitals and hospitals.
And the victim was driving the motorcycle.
Victim was riding a motorcycle,
Riding. Pillion rider.
not pillion rider. Mother,
Then?
column number 23, your lordship kindly see claim application. My lord, column number 23 in my paper book, page 4,
Yes, driving his
On-
own vehicle.
own vehicle. Driving his own motorcycle bearing number so and so through NH on his business purpose, keeping himself to the extreme left side of the road when he reached near Kolaikunda front gate. At that time, suddenly a high-speed bus bearing number so and so, which was coming from Kolkata side towards Odisha side through NH6 with a rash and dangerous manner and above. So, my lord, here there are three, my lord, the oral evidence. PW1, who was the, my lord, the father of the victim injured, Gangadhar Mal.
Yes.
PW2 is a Shapun Mondal. He is the, my lord, the FIR maker and also he is the eyewitness. And PW3, Dr. Pritish Kumar Das, he was the member of that medical board where, my lord, the disability of the victim injured was assessed.
Yes. What is the, where is the certificate?
Disability certificate. Your lordship kindly turn to page 78, 79 of my paper.
78, 79. Only hearing disability.
Speech, but your lordship column number 1. He is a physically, orthopedically speech and hearing disabled.
Speech and hearing disability.
Speech and hearing disabled. Now, column number 3, 92%. And in the bottom, there are under the 4 doctors, signature with rubber stamp and seal, orthopedic surgeon, ENT surgeon.
Any treatment sheet filed?
And your lordship kindly see page 72. Almost. Yeah, it's a matter of I am starting the documents. The first one are FIR. Your lordship kindly turn to page.
I have perused the FIR, charge sheet, FIR, everything.
FIR charge sheet. And also,
Now, these are the treatment sheet or anything has given?
that's his father, divorced to the tribunal. Also, the father's evidence is page 17 to 20. That is paragraph number 2.
Yes.
The excessive high speed and gas unsafe such previous injury on his person, particularly on his head, legs and head. And he has shifted to Bednapur Medical College and Hospital where he was treated as a injured patient. Ultimately, my son became permanent person of hearing and speaking and loss of vision, power of eyesight. And his treatment is still continuing. My son obtained a physical and medical certificate from the which I have filed saying that my son became unemployed person safe accident spending his life as a parasite member of our paragraph 4 that my said son deals in contractor in business in the name and style of quality suppliers and contractors and also general order suppliers steel, sand, cables, chips, cement, etc. 8,000 per month of the said business. I have filed the trade license of my son mobile mark issued by the municipality. That the treatment expenditure of my said son was about 6,000 at the time of funding of March or market future. That on behalf of my son, I filed all the documents in her charge sheet. I pay for compensation of the I have already received 21,000 season 140 of the space.
Yes.
Now, let's go
What is the income tax?
income tax, madam. Your lordship kindly turn to schedule form, page 63 to 67. That is one, 2003, 2004, and page 86, page 68 to 71. There are two assessment here, schedule form my clients has filed.
Yes.
First, your lordship kindly turn to page 63.
All are after the accident.
No. Malad, your lordship kindly see. Malad, very sorry, I say no. Malad, your lordship, I may be corrected. Malad, your lordship kindly see page 60. Yes. Yes, it was Malad. The schedule form is page 63. It was the assessment year of 2003, 2004.
File on?
2003
File on?
It was filed on 29 March 2004.
After the accident.
After the accident. And my lord, your lordship kindly see, my lord, on the same into my lord, column number 26, left hand side. His income, my lord, has been shown is 90,400.
No. The certificate of enlistment
Yes.
and the sorrow, everything filed after the accident. No document prior to the accident. Why not file any document prior to the accident regarding
No.
your running business, everything?
My lord, schedule form, your lordship kindly see. My lord, the
No, one convincing document required, nothing more.
Under the enlistment that is state license,
Certificate of enlistment,
page 61.
it is dated 9th of March 2004, after the accident. Everything after the accident. That is why the order was passed.
No, while a tribunal accepted the schedule form. But
Everything has to be filed and accepted. What is the issue?
Malad,
Everything was you filed, accepted by the tribunal.
but on the contrary, Malad, the insurance company never produced any rebuttable or contradictory or challenge
I-
that or
You have to file any convincing document. You have the running business, you may have some bills, may have some, any bad is there at least. Certificate of enlistment you have received after the accident. Starting business after the accident.
Malad, your lordship is doubting, Malad. my
Yes,
fact.
yes. This is the document. The original document you have filed there. Certificate of enlistment. And on the basis of which you have taken the money.
No, Malad, your lordship,
Nothing is required to be filed. False document. Only your claim is sufficient. But why you file that false document?
false document.
No, for the purpose of for getting the money,
Malad,
getting the
please,
compensation. No, when you said that you have a running business, that is the
no, Malad,
business of supplying goods, materials,
yes.
contractor. Where is the document of your running business? Nothing is there.
Malad, your lordship kindly see, Malad, the observation findings of the tribunal. Tribunal has accepted that I may, Malad, I used to carry the business as a contractor supplier.
That is not the correct finding. I think. How you have proved only your statement? Your statement would be sufficient if you not prove file those documents. Why file those documents? This is the doubt.
Well, so far as my clients possess their documents, in short to file that document.
No, you just peruse those documents.
Yes, I
In-
appreciate what
In
is
your
followed from
clear eyes, you peruse those documents.
I
The
appre-
certificate of
I-
enlistment was
my
prepared.
it is
Thereafter
appreciable
sorrow was
that
filed.
What is minor, what is fallen from your lordship, that was doubting minor, the case is
Yes.
minor. But
Moreover, another is that the person was admitted to the hospital for brain injury. By brain injury for 3 days in a government hospital. No treatment sheet was filed. Thereafter,
the
after 2
medical,
months,
Malad,
after 2 months, he appeared before the outdoor.
yes.
Okay, for physical impairity in ears.
Malad, the doctors, Malad,
But where is the document when he was treated, actually treated after the accident? Nothing is there.
that is the Malad, the conduct of the learned advocates of the Malad, the medical court, who Malad conducted the case, the Malad, the not demanded.
However, we have the
But
document.
Malad, the documents which were Malad FIR on the date of accident, on the fateful date, FIR was lodged. Charge sheet was submitted. And Malad, there are seizure, also seizure lists. There are 4 seizure lists. And the disability certificate, your lordship kindly rely. The
Where is
disability.
Gopal Das Mukherjee?
Huh?
And the 5 minutes before she called me on phone, stating that she will not be able to come today. She has some problem.
Hard in part. Come on tomorrow. As a past matter.
Malad, tomorrow.
Day after tomorrow.
Tomorrow, why she will have a problem because in the day after tomorrow.
Day after tomorrow as a past matter.
Kindly visit day after tomorrow.
Okay, day after tomorrow, first matter. Day after tomorrow. Heard the matter in part, fix the matter for further hearing day after tomorrow.
Paperwork file we kept in the record.
Okay, paperwork file on behalf of the appellant is kept in the record.
Second, my lord. Now, as per your lordship direction, my lord, my High Court Legal Service Committee has
Yes.
appointed me in this matter, my lord. My lord, my petitioner advocate is not here, my lord. Mr. Bahari. My lord, your lordship, last occasion, lordship directed to, my lord. My lord,
Mr. Pahari,
may I-
you are perhaps not come today.
no, my lord. My lord,
So come on
paper
tomorrow,
book is
come on
also-
tomorrow.
My lord, paper book is there, my lord. May I get the copy of paper book, my lord? I don't have any document with me.
Give me the papers. Paper book file. Who filed the paper book?
Well, I don't know. Mr. Pari was saying that you get it from the court.
Achi. What is your name?
Anita Khatri.
Miss Anita Khatri Namnina. Appearing on behalf of the claimant duly appointed by the legal service committee. Receive the paper book, receive a copy of paper book from the court. Let the matter be adjourned today. Place the matter tomorrow for further hearing.
Will you kindly grant me some time? my lord?
You want some time?
Yes, my lord.
Place the matter, place the matter, place the matter. On 8th of September. No, 8th of October. No, it is the 8 is 10. No. 6th. 8 is the Sunday. 6th of October.
6 September and October.
October.
Well, it's 6 October. I have got one matter, my lord, before. court
Then come
order.
come after vacation. Then come after vacation. Let the matter be appear after vacation. After 6, I would not be here.
My lord. Then before 6,
No, before 6 is not possible. Next.
and
She appears. Last week. It's the injury case. Sample announcement.
Come on day after tomorrow. Okay, day after tomorrow.
Make it Thursday.
Day after tomorrow, first up.
OMSC. তো অসুবিধা নেই তো ওয়েডনেসডে
Day after tomorrow, next.
9, 7, 13.
Chip 12 and 13, I beg to appear on behalf of the appellant, your lordship. Mrs. Gopalash Mukherjee appears for the respondent.
Yes.
She is not here, your lordship.
Tomorrow she will not come.
That takes it up.
So
on
you
behalf-
have filed on court.
No, they have filed the court.
They have filed the court. This is your appeal.
Fine.
So come on day after tomorrow. Day after tomorrow.
Wait, your lordship.
14. 17 and 18.
Lordship, I am for the appellant.
You are for the
Appellant.
appellant. And court filed by the New India Assurance Company Limited.
Yes, your lordship. Mr. Shobhendranath Ganguly. As per your lordship, what I have filed 2 affidavit of service. I have served them, but they have not appeared after that.
That is the New India Assurance Company Limited is not appearing.
No, after filing the court, they are not appearing. After the restoration of this case was dismissed. After the restoration, your lordship ordered me to serve the copy. I have already served and I have filed the affidavit of service. But they are not appearing after that.
Give me the papers. Let me see what happened. Mrs. Paul, you appeared in this matter? Yes. This is on behalf of New India Assurance Company Limited. It is possible for you to appear in this matter. No, your appointment has to be made.
Then you also make it next week. For her to take the permission from the court.
Okay. So your appointment has to be made here.
Yes.
Otherwise, it is not-
Officially, yes, yes, she has to appear.
I just inform the media. So appear lordship in that case, again, I'll just take it.
Your lordship, this appeal is
So
only on,
Ganguly, Mr. Ganguly is enlisted with the.
yes, yes. But he's not coming. Yes.
Yes, that is better.
I take it, sir.
Okay, okay. Very well. I want to appoint this.
Next, no, next week.
Very well. Next. Week. Not this week.
Sure.
Number 1920.
Yes, one is this matter is other society. Yes.
Okay, day after tomorrow.
Number 21.
Yes,
For the
Mr.
petitioner.
Uday Shankar Chattopadhyay.
I'm praying for Dr.
Now you have to do the matter. You're not supposed to make submission for not today, not this week, like that. You have to do the matter. If you want to do the matter tomorrow, then I can adjourn.
Sorry, madam.
If you want to do the matter tomorrow, then I can adjourn. Not from the Mr.
Okay,
Chattopadhyay.
my lord, then.
Okay,
Okay, my lord.
very well. Not today. You come with preparation. Next.
Number 22.
Railway authority, my lord, engaged Mr. Subhrendu Pali. But today he has not come. He appeared in the
Appendix. What can be done?
kindly give
In
notice.
this matter, Subrata Santra is there.
Subhrendu sir.
Subrata Santra is there.
Kindly give notice.
Very well, not
And
today.
another matter, my lord, similar to this, another railway matter in which Mr. Subhrendu Satra is appearing, your lordship is pleased to fix it on 20th.
20th.
Yes, madam.
20th of what?
Another matter,
20th of this month.
yes, madam. It was part heard,
Okay. So day after tomorrow.
yes, madam. Then on that day, he will definitely come.
Okay, day after tomorrow.
Number 23. 24.
23.
23, not today, my lord.
Very well. 23 and 24, not today. Mr. Singh, you are for the appellant.
24.
And which for the respondent? Yes, in 24. Which for the claimant? Yes. So I want to know who is the claimant. Very well, very well. So you want not today. Very well, not today.
Number 25.
May it please your lordship. For the respondent, my lord, if your lordship kindly sees the last orders, they are not taking steps in the matter, my lord. This was mentioned at my instance, my lord, if your lordship remembers, batch of 7 matters and few of them, because these are old matters, the appellant is not taking steps. Administrative notice was also directed to be served, my lord. the last order.
Whether administrative notice served.
When the order was passed, my lord, it would reflect from the lordship's, my lord, records.
Appellant deceased. Okay, please take down. This is item number 25.
25.
The Union of India is represented by learned advocate Mr. It appears that the appellant is not represented for quite few days. The administrative notice was served upon the appellant. The registered consignment was returned unserved with a note that the appellant died. Appellant deceased. Appellant is deceased. Considering the return of the administrative notice and considering the present fact and scenario of this case, it is ordered that the instant appeal be and the same is dismissed for default. Stop. Dismissed for default. Any order of stay passed by this court during the pendency of the appeal is hereby vacated. Stop. Any connected can applications, if pending, are also disposed of. Next.
28 and 29.
Respondent,
28 and 29.
not today.
Very well, not today.
30, 31 and 32.
Not this week, Lordship.
Which not this week?
31 and 32.
31, 32. Who are you?
I'm for the appellant, Lordship.
You are representing the appellant. Very well, not this week.
33,
Is 33 is fine.
Who is for the insurance company? Okay.
Hello, people would. Data people would do. Hello, this is a 166 proceeding. It claim.
Yes.
Other the claim was dismissed only on the ground that the claim is passed. Claim is part by res judicata. Why res judicata? Alert one. Initially, once my clients cannot file a claim case under section 160. Your lordship is aware that under section 160A, there is a bar to those persons whose income is above 40,000. Those persons whose income above
No, what happened?
40,000,
What happened in the proceeding?
is 160, initially 166, 163 proceedings, 5. That was dismissed as not maintainable. Thereafter, my client filed under section 166.
Not maintainable, dismissed. Then you have not prepared any appeal.
My lord, if I, my lord, prefer an appeal, suppose. My lord, when my lord, there is a Dipal Bhai case, is my lord, your lordship is aware, which was passed in my lord 2004. Because the Supreme Court says Dipal Bhai case is the my lord, where the Supreme Court my lord deals various points, particularly 163A and 166, 140. My lord, the statute says, my lord, 163A introduced in the year 1994. It is on the basis of structure formula. Structure formula says the person having income up to 40,000 can choose 163, but cannot choose 140 and 163, or cannot, my lord, take 163 and thereafter 166. Many things, my lord.
Then who prevented you to withdraw the case? 163A.
My lord, I have also my lord, I have also bought a decision. My lord, supposing, my lord, a claim case was filed under section 163, where the income is above
Come
40,000.
with the amendment?
Yes. Yeah, my lord, tribunal can convert.
Yes, tribunal can convert, no issue is there.
Yes.
On your prayer, tribunal can convert, no issue.
My lord,
Where there is a judicial order of not
my lord,
maintainability.
I accepted the 163A claim case was not maintainable and it was dismissed. My lord, may I put a question? Can it be a bar to file a, my lord, case under section 166 when my case is dismissed on the ground of maintainability?
No.
May I take, my lord, is it technical?
Yes, you cannot. You cannot do it. As because there are your claims in respect of on a single accident.
Yes.
On the basis of accident, you have
My
a
lord,
judicial order. You have a judicial order. Whatever may be, you have a judicial order. And you, when you are agreed with that order, you have to prefer an
Not
appeal.
I am agree. Oh, yes. My lord, my lord, 163 giving option. If my lord, the person is not,
I understand your
Yes.
submission, but the legal notion is that
my lord, supposing kindly think over. My lord, it is the option of the claimant when the death was occurred or when the injury was occurred. My lord, it is the option of the claimant to choose, my lord, the claim under section 140, 166 or 163 single after amending, my lord, 1994. It is option. Now, my lord, my clients, my lord, has chosen under section 163. Well, as per instruction of the learned advocate or whatever, they do not know, my lord, the 163 is a bar or my lord is of my lord the income was above 40,000. My lord, simpliciter, my lord, the tribunal dismiss the claim as not maintainable. Supposing, my lord, challenging that order, if I prefer an appeal, the result would be same because the statute
no,
is
not the result is there. Here is the question. What you are not understanding. The issue is that when you challenged on judicial order, that order can be looked into in its merits, entirety. But if you prefer another proceeding on the basis of self-same accident, that order cannot be touched. This is the issue. Only appeal you can
My lord,
prefer.
on the point of maintainability, my lord, if my lord, it may be my lord, suppose, my lord, it may be my lord thought that the not another proceedings on the same my lord death, my lord, claimant has wrongly chosen the proceedings which is not
Yes,
permitted under
yes.
section.
Yes, you file one separate application for limitation under section 14 to prefer an appeal against the order of maintenance. By stating all the fact, you have preferred this appeal, that appeal, this proceeding.
Appeal, my lord, supposing my
That
lord,
appeal, this appeal also within that ambit under section 14 of the limitation act. If you prefer now the appeal.
my lord,
against
limitation
the-
act, my lord, there is a judgment, limitation act
No,
has
limitation
no
against the
application.
order of passing maintainable, not maintainable. That case, not this case. You have to prefer appeal against that case.
My lord, your lordship, my lord, I have bought a decisions where my lord, our high court deal to my lord, my lord, not to
As
163
if
or
hearing
161.
appeal against the same order by the same forum.
My lord, my lord, I have bought a decision of our high court where my lord, what happened, my lord, 140, no, 163 case was filed. And my lord, 163 not maintainable. My lord, sorry, my lord, I am finding, my lord, one of case, my lord, yeah, I have argued in this case. 140, 166 filed. 140 was dismissed. Now, my lord, in 166 proceedings, my lord, my client, my lord, did not proceed.
This is
He-
24.
163, my lord, 163 filed. My lord, in the meantime, 166, my lord, dismissed. In 163 proceedings, my lord, the point raised by the insurance company, 163 was awarded.
What are you submitting? 163 proceeded, awarded. What are you submitting? Just read out. Give me a copy.
It was recorded in 2001, ACJ 18. The judgment delivered by Somonis Banerjee, my lord, Ashim Kumar Banerjee. My lord, may I read the, my lord, some portion of the judgment? My lord, this appeal has been preferred by the New India Assurance Company Limited mainly on the
Yes,
two grounds.
140 was dismissed
140 was dismissed
and 166 proceeding was started.
for
Whether it would be res judicata. This is
Yes.
the question.
application under 166 motor vehicle should have been dismissed on the ground that it was barred by the principle of res judicata. The compensation awarded to the claimant was on the higher side and so on and so forth. Now, paragraph 2. For disposal of the present appeal, the relevant of the say that 188 which would come upon consideration are set out for ready refer. Section 140. These are the the statute that we will section 140. Now, thereafter, page 2, section 163A, also described the judgment. Section 166 also described the judgment, and Now, my lord, I am coming, my lord, paragraph 3 of that judgment. Under section 140 of the said act, the claimant is entitled to have compensation for a fixed amount irrespective of the fact whether there has been any fault on the part of the owner or there was any other reason for rejecting the claim on factual basis. Under section 166, a claimant is entitled to apply for a higher compensation in case such compensation is given. Compensation under section 140 is liable to be adjusted. Under section 163, the statute has provided a summary proceeding which is commonly known as ready reckoner for awarding compensation under section 166. That is, an application has a choice either to apply under section 166 or to apply under section 168. But in both cases, the applicant is entitled to that statutory compensation under section 140. In the instant case, the applicant, this judgment was delivered before the by case, judgment delivered. In the instant case, the applicant availed of the remedy under section 140 as well as 163. The application under section 163 has been dismissed by the court below on the ground that it was not maintainable since the business had a income more than rupees 40,000 at the time of occurrence of the accident. The learned judge of the court below, while dismissing this said application, did not go into the details of the matter. The paragraph 7. The application under section 140 came for disposal before the court below. The same was dismissed on the ground that it was did by the principal of the adjudicator, since the application under section 160 had already been dismissed. Now, paragraph 8. Being agreed by and by the said order, the claimant preferred an appeal. During pendency of the said appeal, the application made subsequently by the claimant under section 166 was disposed of in favor of the claimant, holding that claimant was entitled to compensation. The contention of the insurance company that the said application under section 166 was also barred by the principal of this adjudicator has, however, been rejected by the court below. Paragraph 9. Since the claimant already got the award in his favor, he withdrew the appeal preferred by the claimant being agreed by the order passed under section named MO. The present appeal is against the order made under section 166 preferred by the insurance company. Now,
Yes.
paragraph 11. Section 11 of the Code of Civil Procedure pass a party to register an issue which has reached its finality in another proceedings between the same parties. The application under 160 was dismissed on the ground it was not maintainable since it was having an income for more than rupees 40,000 and there was no adjudication on merits. Hence, the applicant was entitled to avail of the other remedy available under the Act, namely section 140, 160. We have no hesitation to say that the order passed by the court below under 140 was erroneous, as the court below, while dismissing the application under section 140, misconstrued the provision of section 11 of the Code of Civil Procedure. Although the appeal preferred from the said order was withdrawn by the claimant, the claimant is entitled to challenge the said order in collateral proceeding. Since the said order is nullity has been held in the Supreme Court in the case of Hiran Singh and others, says Chaman Pasha reported in All India Reporter 1954. Wherein the Supreme Court was of the view that if an order is a nullity in the eye of law, the same can be challenged in any other collateral proceeding. We feel, paragraph 2, we feel that the learned judge of the court below, while disclosing the application under section 166, has very rightly rejected the convention of the insurance company to the said effect and held the said application under section 166. Accordingly, we hold that the said application under 166 of the Automatic Act made by the claimant was made. and we are in total agreement with the learning class of the board below on that score. My lord, this is the case, my lord, where my lord 163 was filed, 163 was dismissed, thereafter 140 and 166 filed. 140 was dismissed, against then appeal was preferred, but thereafter 166 was awarded. Now, my lord, 166 award was challenged by the insurance company before this court and raised the point that since 163 and 140 was dismissed, so the principle of res judicata will attract. Our High Court, my lord, says no. It's a
Whether
collateral.
you have annexed the order of non-maintainability in this case.
My lord, that was in the record. That was, my lord, what the tribunal says. Tribunal says,
Page 8. Para two.
page 8. Yes, my lord, your lordship says, my lord, court holds that the case under section 163 is dismissed not only on as non-maintainable, but also on merits. Now, my lord, kindly go through, my lord, the judgment which was passed under section 163. My lord, most of the, my lord, part, though I have not annexed, but I have got most of the part deals, my lord, since the, my lord, the issue of, my lord, more than 40,000, the case is not maintainable. And one paragraph which was said that here the owner has not come to prove that he is the owner of that.
Case order. That is meritage this.
Yes, if I challenge, my lord, if I challenge that order, ultimately result is 0. Why? Because, my lord, in Dipal Bhai's case and also the statutory provisions, my lord, the person whose income above 40,000 cannot maintain, my lord, a claim application. If I succeed, my lord, in the appeal, my lord, remanded the matter to the tribunal. Tribunal again, my lord, cropped up question that under statutory provision, my lord, section 163 is not maintained. My lord, it is a technical issue. My lord, your lordship kindly appreciate this is a case, no doubt. It is not a case of, my lord, a simple injury case. 140 death case, and it was proved by of sufficient documentary evidence. Claimants, my lord, deposed, eyewitness deposed, and also, my lord, there are another eyewitness, my lord, income, my lord, since the accident took place 2007, income may be assessed, my lord,
No, no,
3,000.
this judgment is not applicable in this case.
My lord,
This ratio. Mr. S. Banerjee.
my lord, this judgment is, my lord, so far as, my lord, kindly appreciate, here 163 was dismissed, 140 was dismissed, 140 was preferred appeal. Now, my lord, in the meantime, tribunal 166, my lord, awarded. Insurance company, without accepting the.
So it is the observation, no merit was discussed in both the cases.
My lord,
Here is the specific finding is there.
my lord, today I have not got, but today I have not got that judgment, but there is a judgment of our High Court where I argued, my lord, it's a technical issue. My lord, supposing, my lord, order 23, rule 1, my lord, when the civil proceedings, where the suit was, my lord, pray for withdrawal with a liberty to file a fresh suit. My lord, the suit code can grant under order 23, rule 1. My lord, that point was raised, that this case, no liberty was given to file a fresh suit.
Where it was raised? In which petition?
My lord,
In which case? In 163, 166
my
percent?
lord, tribunal, in
Before
one,
the tribunal?
before the not in this case, but another case I'm submitting. My lord, 163 withdrawn, 166, whether the tribunal holds the liberty was not taken from the tribunal to file a fresh suit. Even if the case was dismissed on merit or not. Now, the point raised that whether it is a barred by the principle of res judicata or not, whether the technicalities, particularly in a motor accident proceedings, where the Supreme Court time and again says that technicalities, niceties, hyper-technical are not issue in disposing, but a death was caused due to the motor accident. The proceedings is not permissible. Proceeding was dismissed. Now,
You cannot be deprived your life,
Yes.
personal liberty without a due procedure of law. This is the rule. This is the constitution. You have to adopt
But
the
your
due
lordship,
procedure of
kindly see, if the statute does not permit me to get compensation in that proceedings, I cannot choose another proceedings. Even if
If you have the liberty to withdraw the same, why you prefer to contest the matter? Proceeded with this matter.
my lord, in that case, that was in the lower court record. Your lordship, kindly go through. The tribunal holds that the case is not maintainable as dismissed, but case is also dismissed since the owner has not come forward to prove that he was the registered owner of that vehicle. This is the grounds, my lord, for that, my lord, 163 proceeding dismissed, and my lord, 166, my lord, is a bar. My lord, your lordship, kindly appreciate, my lord, the Supreme Court time and again says technicalities, proceedings of civil procedures, my lord, the my lord, criminal trials are not to be followed. Simpliciter, my lord, the death was caused, the nearest person or the dependent, my lord, the lost life.
Yes.
Now, my lord, the claimants are entitled to get, my lord, the compensations. Whether, my lord, the technical issue or maintainability or not maintainability. It is a true, my lord, if your lordship Dipal Bhai's case, my lord, go through, my lord, Dipal Bhai's case, my lord, thoroughly, my lord, discuss that when, my lord, a person chooses a proceeding under section 163, my lord, the door is closed for, my lord, paying, my lord, more compensation in another proceedings, because 163 proceeding is final. My lord, before Dipal Bhai, Supreme Court also
So you cannot file 163A once and
on
146.
148.
That's why you cannot proceed 166. Yeah,
No, my lord,
this
here,
is the principle, very basic principle.
my lord, the Motor Vehicle Act says, my lord,
You can proceed 166,
See,
163A,
and
thereafter
163 award is final. Or you can adopt
that means the award for
140
not
or
maintaining is final.
166.
That is the award that is denying you is the final.
Final. The award is final.
Yes,
As-
I have gone the judgment. It is a very meritorious judgment. At least 7 case laws are discussed regarding the merit of the case.
My lord,
7 case laws of
in the
Supreme Court and
impugn
High Court.
order, which I
No,
appeal,
no. That's 163A order.
160 order, 7.
At least 7 to 8 case laws are discussed regarding the
Yes.
merit of the case.
No, where your lordship kindly see, I have also, my lord, in the impugned judgments, my lord, tribunal relied on certain decisions, which I brought. In most of the judgment says, the claimant can pray for conversion, or the tribunal has its somoto convert the case from 163 or to 166. About the decisions in 2008 ACJ, 2008 ACJ, 2009 ACJ, which the tribunal relies. ACJ 112. Now, my lord, the tribunals relies, my lord, the decisions. The case of Himachal Pradesh, it was reported in 2008 ACJ. Now, paragraph 345. My lord, here the paragraph 2 in this judgment also, my lord, discuss the Kodala's case. Raj 5 versus Kodala case, which was reported in 2001 as currently cited. Now, my lord, I shall be reading from paragraph 3. Since the tribunal has improperly exercised the jurisdiction regarding the award invalid on the ground alone, whereas the claimant's respondents number 1 to 4 shall be punished for his error on the part of the tribunal, and in that light, I find that the prayer of Mr. Thakur deserves to be considered of and that the of claims. Paragraph 40 following allow the award is exercised only on the legal ground that on the face of the award it suffers from a patent error of law in as much as the tribunal properly exercised jurisdiction under section 16 of the Act was award, even though under section 1 of the Act was not because the income of the critics on the whole showing of the claimants as well as what was proved during the course of the evidence that was more than now, allowing the prayer of the claimants, respondent numbers 1 to 4, I permit them to file an appropriate application before the tribunal or court under section.
Yes, these order you required to take from the High Court against the order of dismissal.
Or when the manner case has been manner finished. Manner if there any part manner to file the case manner where manner I proceeded the case. Ultimately, in conclusion, the tribunal holds whether the claim case is not mentionable since it is by the principle of justice. As because manner I may put question to myself. When the proceedings was dismissed as not maintainable or anything, manner, is there any part manner as per the provision of manners CPC manner or any other law? Because it is under the beneficial social welfare legislation.
Finally decided issue is there. Finally decided issue is there. So
Yes.
you have to challenge the decision before the appellate court.
My lord, appellate court, my lord, your lordship has gone through, my lord, when Mr. Singh, my lord, has says, Kanai Manna. where my lord 163A, my lord award was passed. My lord, for inadequate award of compensation, Kanai Manna, that's case, Kanai Manna has preferred. From the insurance company, it was there. It is a case under section 163A. It is not maintainable. That Kanai Manna's case was dismissed as not maintainable, but at the same time granted liberty by the Honorable Division Bench if the amount which was received by the claimants be returned with interest to the insurance company, he can obtain the proceedings under section 166. There is no the technical issues, simplicity, in order to get the just compensations, under the Motor Vehicle Act, whether it's permissible or not. Kindly appreciate the young boy, aged about 29 years, died in a motor accident, and his wife and son, mothers claim compensations. Due to the trappings of the provision of section motor vehicle,
You can file 140, thereafter 163. You can file 140, thereafter 166. But you cannot file 163A, thereafter 166. This is the law.
The village people, depends on
Again, come on with the village people.
not
You are dealing with all the matters, now you are coming with the.
not, I am not dealing village people. Sometimes, we have a educated, rich, the claimants. Here, listen, kindly appreciate the Momtaj Bewa. He is residing in a village, rural area. He depends on his learned advocate who conducted the case. Learned advocate who filed the case. And more so when your lordship kindly see what are the objections as raised by the insurance company. Insurance company has no objection. Your lordship kindly see, if you go through the judgment, insurance company has not put any objections.
They need not to. They need not to.
Because the advocate knows that the claim case that in earlier proceedings as non-maintainable, this case is maintainable. In spite of that, the tribunals, my lord, whether it is on his personal grudge or not, my lord, dismiss, my lord, the claim. What my lord clients have, my lord, committed error. What my clients, my lord,
no, you have made such submission before the learned tribunal that the earlier matter was dismissed not on merit or like that. But there is a specific observation of the learned tribunal. Come on page 6, page 7.
Yes, my lord, that
the matter was dismissed on merit.
Dismissed as not meant, it is maintainable as also on merit.
Yes. The
But-
earlier matter was dismissed on merit. That's why he need not to go into the merit further.
My lord, your lordship kindly appreciate, my lord, these, my lord, merit or non-merit or maintainable, not maintainable. For that the claimants would be deprived for getting compensations.
No, then why you were before the learned tribunal come directly to the High Court to get a compensation? That would be proper.
My lord, here the appeal is, my
Before
lord,
the Supreme Court for getting proper compensation. We have to go through the procedure of law. Otherwise, we cannot.
my lord,
There may have your liberty that you are a claimant and you are poor claimant.
my lord, that,
So
my
law
lord,
is there to
that
protect you.
order 23 rule 1 is not strictly followed in a proceeding under section 1 of motor vehicle. Even if,
Order
my lord,
23 rule 1 is an application where the plaintiff has to file it. Plaintiff has to file it.
plaintiff has.
Yes, plaintiff or the
wishes
claimant
to-
has to
to,
file it.
my lord, to get the suit, my lord,
Plaintiff has to file it either he withdraw the suit without any liberty or with the liberty. This is the option of the plaintiff.
This is not the suo motu action of a court. Just read the specific provision.
Yes, I have gone to for that. I am not disclosing that there is a specific provision under order 23 rule 1. Now, my lord, kindly my lord, the findings of the tribunals where my lord, where the insurance companies advocate time and again says, even if cross-examination has not put, even if my lord, there is no objection in the written statement.
I am not going to the merit. You have to have to cross the hurdle.
My lord, hurdle, I can, if your lordship, my lord, is so tight. So, my
No,
lord,
I am not tight. I am just discussing with the law. I am not tight.
My
on
lord,
the receipt like that.
my lord, I would submit, my lord, I would submit that the tribunals one rejected is not a bar to, my lord, file a case on the same.
If allowed, if allowed, on
Supposing
63A,
my lord, tribunal says it is not maintainable.
no, if allowed, this is the final order. You say it's a final order, whether allowed or dismissed. It's a final order. This is the notion. It's a final order. So whether
My lord,
after
supposing
that
my lord,
final order,
if
you
the
can file
claimant,
166.
if the claimant did not, my lord, properly get my lord instruction to challenge that award to higher authority.
Yes, there
Or
are the
if
scope.
he,
You have to prefer specific provision of law.
my lord, at this stage, after my lord 10 years, 8 years, there is limitations, my lord.
No
That-
limitation is there under section 14. If you proceeded in separate forum, which one or which you were
My
not
lord,
able to-
163 at present, my lord, is vanished. 163, my lord, the second schedule, 40,000 cap is vanished or abolished.
whatever may be, you can proceed again, no issue. You may have to get liberty from the High Court from the appellate court to get the opportunity to file a specific application before the.
My lord,
specific-
your lordship is not entertaining this appeal.
How can I enter?
Because I would submit, my lord, the relying
Yes,
on.
file, yes, rely the judgment on the next day. We don't have the time today.
My lord, then, my lord, your lordship kindly give 1 week time, because I will search that judgment where
Very
technicalities 140
Then come on after vacation.
after vacation.
Yes. That means the,
Then Lordship will kindly keep it as part heard, Lordship.
Why
Because
part heard?
I couldn't have argued better.
Part heard means, my lord, it's
I couldn't have argued my case better. I'm grateful to my Lordship.
since your lordship is, my lord, in my learned friends, my lord, side.
He
Now
doesn't
he
want
says-
I am not any other side.
My lord,
No, I would not be available since 9th of October. Okay, that's why.
Malad, it
I would
would
not be
be-
available since 9th of October to 19th.
not,
Yes,
because
for the circuit. court.
Wow. No, after Puja vacation, your lordship.
Then Lordship will keep it as part heard, Lordship, kindly.
Argument, next part.
Part
Argument heard on behalf of the appellant in part.
And leave your-
The paper book filed on behalf of the appellant is taken on record. Let the matter appear after vacation as a part of matter.
And just one, Lordship, I don't have in this paper, Lordship. The what passed in the 168 proceeding, Lordship,
Was not there.
which has not been exhibited.
No, it was not exhibited. But Malad in the Malad.
In the impugned judgment, only that portion is there.
Let my Lordship can give me a copy of that.
Malad, I
Whatever-
have a copy which by if he Malad 6 Malad, that copy I can.
You can, yes, you have. Just,
Malad,
you don't have to file any supplementary. paper.
Malad, before rising on game,
Malad, supplemented paper book, Malad, that copy is not, because Dwarko Decode has reached to this honorable court. And Malad, this copy which are sent by Nadir Feduk conducted the case. My lord,
Okay, okay, you file that, you will serve the copy.
yes.
Before writing, may I mention one, second type, my lord, have a problem, my lord, item 38, my lord. Item 38 of today's list, my lord. My lord, paperwork ready, my learned friend is there, my lord. And only, my lord, may I submit my paperwork or kindly fix a date for hearing, my lord, only.
Come on tomorrow, come on tomorrow.
And kindly make it not today, my lord.
Yes,
38.
it will be all will appear tomorrow.
Yes. 38 not today.
No, only one matter is there. It would be specially fixed matter. It is on 15, not 14. ছিল। রেখেছেন? I shall continue with the list, today's list. Yes, yes. You comment. Yes.
Yes.
Specialty matter item number one.
I appear for the university. But this, I appear for the writ petitioner.
Yes. Yes, Mr. Murinder.
But my client
Yes.
was an employee of Dhanchandra Krishi Vishwavidyalaya. Now, Uttarbango Krishi Vishwavidyalaya was set up sometimes in 2000. During this transitory period, employees from the BCKV, not the Lordship can well appreciate, these are very specialized universities.
Yes.
Not imparting education in the general branch of law. Now, employees of BCKV, Dhanchandra Krishi Vishwavidyalaya, I am referring to as BCKV, and Uttarbango Krishi Vishwavidyalaya, I am referring to as UBKV. But both had their respective statutes. Now, employees of BCKV were transferred to UBKV because UBKV was in its transitory process or mode. Employees who would not exercise option, they were deemed to have exercised option and moved to UBKV. My client opted and became an employee of UBKV. Now, by reckoning his 22 years of length of service from BCKV,
Yes. Yes.
the Executive Council of UBKV decided to refer my case for upgradation to the rank of lecturer to the state government. Now, two factors weighed with the Executive Council and the state government.
Now you are in the post of.
I was in the post of Superintendent Technical.
Post of Superintendent Technical. And you belong to that post in BCKV, and you are also opted to UKV on the same post.
Yes.
Yes.
Now, all employees of BCKV, they had been granted the benefit of this upgradation after rendering 20 years of service. Upgradation in scale. Probably at that point of time, it was in the nature of career advancement scheme, something like that. I'm not taking these two factors into consideration. One being my qualification, because by 2004 I had obtained PhD after completion of MSc. Number two, the
employees alike the writ petitioner in BCKV who had been granted similar benefits, and I would have got the same benefit had I been retained in BCKV. And number 3, relying upon a 1993 government order which was dealing with the scales of lecturers, but the government approved the EC resolution and gave its no objection towards my upgradation to the rank of lecturer.
Yes.
This was done in 2010. Now, it so happened that after 4 years, there was an election procedure in the
So in the year 2010,
10.
you were upgraded.
Yes. But the decision to upgrade was taken
Yes. By the executive
by
council.
the Executive Council after
Yes.
receiving no objection from the government.
Yes.
And there were 2 additional increments given for obtaining PhD for higher qualification.
Yes. What happened then?
Then the requisition was sent to the government for pay, and all these things were going on. In the meantime, in 2014, the election process in UBKV was in force, and I put in my candidature as a teacher's representative. The election tribunal, which was presided over by a learned district judge at that point of time, he did not accede to that. And behind my back, I was reversed from the rank of lecturer to the rank of technical superintendent. But I approached this honorable. In fact, I had applied before the election tribunal as well for getting myself impleaded, when the tribunal said, no, we are not deciding upon your rights. We are only deciding on the question of election. So you are not required to be added as a party in the proceeding. So I was thrown out of the proceeding, but behind my back, the election tribunal held this, and ultimately I was reverted by UBKV from the rank of lecturer to the rank of superintendent technical on the basis of the tribunal's order, election tribunal's order. Okay. So I approached this honorable court.
No, whether there are any order of executive council to that effect after the election council?
Yes, there is a UBKV, not executive council, it appears that is issued by the Vice Chancellor.
Very. Revert back to the same superintendent technical.
I have prepared a short list of dates.
Yes.
And that was straightway on the 3rd page, 26/11/2014, the middle portion of that 3rd page.
Yes.
When I filed a writ petition challenging such reversion order, the court set aside the same and allowed UBKV to pass a fresh order.
Very.
After providing opportunity of hearing. That's on 13th April 2015. Sorry, 19/1/2015.
19th January.
Yes. Number on remand, the Vice Chancellor of the UBKV, not the Executive Council, passed an order upholding such reversion.
Vice Chancellor.
Yes.
Initially, you challenged the order of Vice Chancellor.
Vice Chancellor.
Again, the same Vice Chancellor
Yes.
passed the order.
The court remanded it to the UBKV, not the Vice Chancellor.
Yes.
Now, I made a representation to the Principal Secretary Government of West Bengal, I must say erroneously, because there is a provision for interpretation of any order. But the government said we don't have jurisdiction over this issue because it's not a question of interpretation.
Yes.
That's on 21st of June 2017. Now, on 25th July 2017, I joined the reverted post of Superintendent Technical
Without
prejudice to my objection with regard to the reversion.
So this is the repetition.
Now the ground taken by the Vice Chancellor, which my learned friends on the other side cited, that in a subsequent EC resolution, this order of the Vice Chancellor was approved. So this is a question of approval of the order. Now there are 3 grounds taken for the purpose of rejection. If your Lordship kindly takes page 159, that's the order implemented on remand. Straightway comes to page 166, these are the findings.
Yes.
The first issue is that a person who for all intents and purposes is a non-teaching employee cannot by any stretch of imagination be designated as a teacher. That too without resorting to any proper selection process. Appointment of a teacher either in a college or a university is made in strict consonance with the norms. There are various issues attached to the appointment of a teaching staff in any college or a university, or for that matter in educational institution. The qualification attached to a teaching post is not the same as that of a non-teaching post. A stringent selection criterion is employed for appointment of a teacher. A person whose appointment is to a non-teaching post cannot suddenly be made a lecturer by stroke of a pen without resorting to a proper selection criterion. By dint of an order, a non-teaching post cannot be converted into a teaching post. In other words, approval at the highest level is missing in the facts of the present case. Please take note of this sentence.
Yes.
So whatever might be his opinion, his final conclusion as regards this point was approval at the highest level is missing in the facts of the present case. So we may have to ponder over the question as to who is the highest authority.
No, the government has issued the no.
I am deeply obliged. That's my point. And not the Act says in the matters of creating posts or laying down service conditions or pay. The Act means the Act of UBK. The government approval is required. Once the government has approved, the university is stopped from taking a contrary.
The other day, there are instances of BVKV regarding such issues are there. Non-technical staffs has been upgraded to the.
This is it's in the proceeding. It was the first case. Yes. Because my client had joined from BCKV. UBKV was in its nascent stage, was in the formative situation. This was the first case where an employee from BCKV has been transferred and had completed 20 years of service by reason of his initial appointment in BCKV. This was really in the nature of an upgraded pay. And what his Provident Fund gratuity, all those have been transferred from BCKV to this establishment. Interestingly, it appears, coming back to the order.
Yes.
It appears that by a communication of the state government dated 8 February 2010, the erstwhile Vice Chancellor of the university was directed to place the matter before the Executive Council as per relevant provisions of the Act and Statute, before taking any final decision with regard to your redesignation and upgradation. However, that was not done, and the letter was never brought to the notice of the EC. However, before the EC comprising of condescending members, despite lack of quorum, this is the second point, lack of quorum. The matter was discussed in the 42nd meeting, although in between 8th February 2010 and the 42nd meeting of the EC, which was subsequently annulled in the 41st EC meeting, took place, where anticipating stringent opposition, the matter was not discussed at all. Similarly, though the matter was first placed in the 40th EC meeting, it was not discussed and decided anticipating disapproval. Dr. Ghoshal, you may theoretically claim to be a teacher. Since the earlier Vice Chancellor decided to confer on you certain benefits to which you were not legally entitled to. Pausing here for a moment, when my client in 2000 had joined the service of this UBKV, but my client had conformed to all the UGC regulations for the purpose of appointment of a teacher. He was MSc, he had the requisite percentage of marks, and he had the concerned subject also. The clandestine understanding between the erstwhile authorities and you is apparent. Please see. the university is challenging its own order or action. University cannot say that my previous action was clandestine.
Yes.
And U is apparent since the erstwhile registrar chose not to act in terms of his own communication of 22nd May 2008 and decided not to place the issue before the executive council of the university till a point of time when only condescending members were available. In the 42nd meeting, despite lack of quorum, the issue was passed because of the involvement of the condescending members who decided to toe an illegal line while conferring a status on an individual like you who was never a teacher. Had such conferment been upon undertaking a rigorous selection criteria, then the matter would have been otherwise. The erstwhile Vice Chancellor went to the extent of amending the statute to suit his own convenience, which is unheard of and is unimaginable. The government, on coming to know of the entire scheme of things, did not approve such endeavor of the erstwhile Vice Chancellor. As a consequence whereof, the decision adopted in the meeting had to be annulled. However, independent of any decision of the EC or the university, the question is whether a status can be conferred to you by stroke of a pen. On a careful scrutiny of the documents or various decisions referred to, it does not appear to me, so it was his individual, that there is any material produced by you supporting your case regarding conferment of teaching status. You have referred to various decisions of Vidhan Chandra Krishi Vishwavidyalaya and have placed strong reliance on the same. I say that a decision which is illegal cannot be cited as the sheet anchor of another purported illegality. In other words, one wrong cannot give rise to another wrong. At some stage, one has to strike a balance. On a careful scrutiny of the government order dated 8th or 9th October 1993, it clearly appears that the subject matter of such government order was appointment of existing demonstrators in non-government colleges with postgraduate qualification as lecturers. The issue is whether a technical assistant working in such capacity by any stretch of imagination is regarded as a demonstrator. The second issue is, even assuming that a technical assistant and demonstrator are one and the same post, whether it is open for the authorities to take into cognizance a decision applicable to demonstrators in non-government colleges and apply the principle of such decision in your case. The chain of events also is quite interesting. You failed to give a satisfactory reply as to what prevented you from applying in the year 2006 or 2007, since your first application on the issue was made in 2005 and the application which has been acted upon was made on 5th May 2008. It is presumed that you had your favored coterie of officers in the administration in the year 2008. You must have felt that those officers would toe your line and somehow confer on you a status to which you are legally not entitled to. There is a wide difference between a teacher and a non-teaching employee. The benefits applicable to a teacher are ordinarily not applicable to a non-teaching employee, and there are no extraordinary situations which permit a non-teaching employee to suddenly adorn the post of a teacher, that too of a lecturer. The norms applicable for appointment as the lecturer are quite well known. You have never been appointed as a lecturer, and the career advancement benefit applicable to non-teaching employee does not enable you by any stretch of imagination to be conferred with a status by virtue of career advancement to which you are not legally entitled to. I say this because career advancement of a non-teaching employee is distinct and specific in the UBKV or the statute. Such distinct and specific provisions contained in the statute cannot be brushed aside by certain persons who are bent upon perpetrating illegality. The illegal design to confer on you a benefit by manipulating things to suit the convenience of the persons clearly and amply demonstrate the evil intention of the parties, that is, the erstwhile administrators in the university administration, whose decisions were put to rest by the government. Please take note of this. Whose decisions were put to rest by the government. In such view of the matter, looking into the representation furnished by you vis-a-vis the documents produced by you, and having regard to the law on the subject, I am of the firm and established opinion that you, having been appointed as a non-teaching staff, cannot be treated as a teacher in the name of upgradation and redesignation by any stretch of imagination, and the order of the former Vice Chancellor of 14 September 2009 stands withdrawn forthwith, and you are forthwith reverted to your earlier post of Superintendent Technical in the cadre of non-teaching employee. The additional pay which has been illegally disbursed to you from 1/6/2008 to till date shall be adjusted from your salary month by month by deducting a reasonable amount every month for which separate order shall be issued. Additionally, the decision to grant you 2 advance increments for acquiring PhD degree being grossly improper is withdrawn forthwith. So 2 things will not stand out clear from this order. 1, he is against his own university's or executive council's decision. Number 2, although he is conscious of the fact that the decision of the executive council was put to rest by the government, he still takes upon himself the duty to negate such decision.
Yes.
Thirdly, he proceeds on presumption. Every time your lordship will be pleased to find from every paragraph, even if it is assumed, then I presume this. So this is clearly presumptive. Now please see the government's order at page 118. Please see 118. Vice Chancellor has been pleased to accord his kind approval towards following fixation of pay of Dr. Kushal, lecturer, who has been upgraded to this post with order dated 14 September 2009.
This is a UVKB order.
This is UVKB. I just showed to your lordship that it was fixed, but the order has 2 aspects. One is reverting and then not recovery of pay. So his pay was upgraded with the order of 14 September 2009. And the Vice Chancellor had approved the fixation. Now kindly comes back to page 117.
Now 118 is the order
of 2010 by which my upgraded pay was approved.
Upgraded pay was on 23rd of April.
Yes.
Yes. 117.
PC 117. That's the order. The page 118 was referring to 14 September 2009. This is 14 September. In terms of the provisions of UBKB Act 2001, read with clause numbers 53, 56, and 57, 8, and government order dated 24th August 2009, Dr. Ghoshal, Superintendent Technical of the Department of Agricultural Entomology, Faculty of Agriculture, UBKB, Kuch Bihar, is hereby designated and upgraded to the rank of Lecturer, Department of Agricultural Entomology, UBKB, with effect from 1/6/2008. That is, after completion of 22 years continuous service in the rank of Technical Assistant in the same department with MSc and PhD degree on the following terms and conditions. 1. He shall, on upgradation to the post of lecturer, enjoy the scale of 8,000 to 13,500 along with other usual allowances as applicable to that of a teacher of the university. He shall hold the designation of lecturer in view of research activities and shall discharge duties of lecturer in terms of UBKB Act and statutes or of similar nature of duties as performed at present. That is, as he was performing prior to issuing of this order. But he was really performing lecturer's duties. That documents are included. The placement and designation shall be personal to him. His pay on upgradation shall be fixed with effect from 1/6/2008 in the scale of 8,000 to 13,500 as per usual norms prevalent in the university, subject to the condition that he shall be entitled to draw area payments for such fixation with effect from 1/6/2008 on receipt of grant from the government. His service shall be governed by the provisions of the UBKB Act, ordinance, statutes, regulations, and rules framed thereunder, and the resolutions of the appropriate authority of the Vishwavidyalaya. The appointment order is provisional, subject to approval of Executive Council post facto.
Yes.
He shall submit a formal acceptance to the undersigned and shall submit joining report through the proper channel at the earliest. So, but this also refers to the government order of 24th August 2009. Yes. Please see now. Page 108. That UBKV was writing to the government on 22nd May 2008.
Yes.
But I skip over the first paragraph. This is reference. Please see. Please find enclosed here an appeal received from Dr. T.K. Ghoshal, Superintendent Technical Department of Agriculture and Entomology of this university. Dr. Ghoshal requested to the administration for his upgradation to the post of lecturer in agricultural entomology following GO of 9th October 1993. And this is the same GO which the Vice Chancellor had referred to in his impugned order.
Yes.
And submitted his self-appraisal annexed with relevant documents in support of his prayer. It is to state here that Dr. Ghoshal has joined Technical Assistant Grade 3 under erstwhile North Bengal campus of Bidhan Chandra Krishi Vishwavidyalaya and transferred to this university by the provisions laid down in its act. After establishment of this university in February 2011, all promotional benefits due to him have been decided by UBKV Act 57(8). The policy of upgradation as mentioned above has been operative since the year 1993 and is in vogue till date in the former university, that is BCKV, in which the concerned incumbent had rendered his service as an employee in the same category till he was transferred to UBKV. Since it is the first case of similar nature in this university after its establishment, it is felt appropriate to have due concurrence from the state government before taking any decision by the statutory authority executive council of this university for its implementation. An early action from your end would be very helpful. Please turn over to page 109.
Yes.
The subject is upgrade. This is dated 24th August 2009. Now, this was also referred to by the Vice Chancellor in his impugned order. The date is immediately after the address from Joint Secretary to the Vice Chancellor UBKV, dated Kolkata, the 24th August 2009. Subject: upgradation and redesignation of Dr. T.K. Ghoshal in the post of lecturer.
Yes.
With reference to the UBKV's letter of 22nd May 2008 at the previous page. On the subject noted above, I am directed to say that this department has no objection to redesignate and upgrade Dr. Ghoshal to the post of lecturer in the Department of Agricultural Entomology, UBKV, Kuch Bihar, as he joined erstwhile North Bengal campus of BCKV in the year 1986 under BCKV Act 1974 and transferred to UBKV in the year 2001 in terms of clause number 33 and 56 of UBKV Act. So, and please see what was the, kindly comes back to the previous page, page 108. There is an enclosure to that letter. Enclosure is application of Dr. T.K. Ghoshal along with documents attached with the letter of his self-appraisal. That 1993 government order, all documents, self-appraisal, this recommendation of university. And this was consciously decided by the government, keeping in mind the provisions of section 33 and section 57 of the two acts of the act.
Yes.
And section 33 and 56 of the act. And what was done in 2009 was sought to be reverted in 2015 by the Vice Chancellor himself, single-handedly. What happened in the meantime? Now, this was subject to the approval of the, your Lordship has been pleased to find from the recommendation letter at page 108. Please see 3 pages from the repetition, the 40th, 42nd, and 43rd EC meeting. First document is at page 120. Now, the situation is, the sequence is like this. Now, I approached the university. University sent it to the government. Government said, I give no objection. Then it was placed before the EC. EC approved. Then my pay was upgraded.
Order was passed. Then, yes.
Upgradation of pay. Please see the EC meetings at page 120, which the Vice Chancellor had been pleased to observe that these were non-est because of non-availability of quorum.
Yes, 120.
agenda of the 40th EC meeting at the top.
Yes,
And it takes item number 40.22, the last agenda on that page.
yes,
Upgradation and redesignation of Dr. Ghoshal. Vidhan Chandra Krishi Vishwavidyalaya had adopted the policy since long for upgradation and redesignation of technical assistants possessing MSc and PhD degree and serving at least 22 years to lecturer in the concerned department. In accordance with this policy, BCKV had given the benefit to a number of incumbents following the GO of 9th October 1993. Dr. Ghoshal applied for the same benefit. Receiving his application, the university wrote to the government for permission of giving the same benefit in terms of clause number 53, 56 and 57.8. The government in his letter dated 24th August 2009, that's the page 109 letter, has given permission stating that the department has no objection to redesignate and upgrade Dr. Ghoshal to the post of lecturer in the Department of Agricultural Entomology, UBKV, Kuch Bihar, as he joined erstwhile MBKV campus in BCKV in the year 1986 by BCKV Act 1974 and transferred to UBKV in the year 2001 in terms of clause number 53 and 56 of UBKV Act.
yes.
So this was the 40th meeting. Then please see the 42nd meeting at page 121.
Second meeting.
Yes. Item number 42.07. Same subject, upgradation and redesignation of Dr. Ghoshal. Referred item number 40.22 of the 40th EC meeting.
Previous meeting.
Yes. But the first two paragraphs is really quoting from the previous page. I am not
Yes,
reading it once again for your Lordship's time consideration. Then the penultimate paragraph on that page. Dr. Ghoshal, Superintendent Technical, has been provisionally redesignated and upgraded to lecturer after completion of 22 years continuous service, having MSc and PhD degree, submitted for reporting to the Executive Council and post back to approval.
yes. Next page.
Please see now page 123, the 43rd meeting.
123. Yes. Now, what about the next page? That is 122.
Several that is flowing from the previous page, that's 42nd meeting.
42nd meeting.
The agendas are 42.07, 42.08, 42.09.
4207 is last part is there.
That is
Executive.
this upgradation, and yes, is exclusively personal to him. This decision stands confirmed.
Yes.
Then please turn to the 43rd meeting. So in the referred meeting confirmed the earlier. Please see the 43rd meeting.
Page 123.
123.
Yes.
At the beginning, the chairman spoke. So please see, there were 9 members attending the meeting. 9 members present.
Yes.
In the confirmation part, the proceedings of the 42nd meeting is confirmed with following amendment and correction. 43.01, confirmation of the 42nd meeting of the EC held on 10th April 2010 at meeting room. The proceedings of the 42nd meeting was confirmed with following corrections. Item number 42.03, this is not concerning me. 42.06, not concerning me. 42.27, not concerning.
Yes.
Then please see the 44th meeting at 124. Regarding admissibility of 2 increments. So, my lord, my upgradation had been approved. Now comes the question of 2 additional increments by reason of PhD acquisition. While in service in the, it's item number 44.40. While in service in the university as technical assistant, Dr. Ghoshal acquired PhD degree with permission in 2004, and he has been redesignated and upgraded to the rank of lecturer with effect from 1/6/2008. There are 2 GOs in connection allowing 4 increments for having PhD degree at the time of joining as lecturer and 2 increments when a lecturer acquire PhD degree in his service career. Copies enclosed. Now, in view of the prayer of the incumbent concerned, it is to be decided if the benefit of 2 increments may be allowed to him as per the aforementioned GO. Submitted for discussion and decision. Now please come to page 125.
Yes.
Demand for salary grant for pay and allowances for teaching and non-teaching staff, officers and research scholars of the university, regional station and farms of UBKB, and contingency grant for the months of August 2010 and September 2010. I am sending here with our demand for release of salary and contingency grant for the months of so and so. The demand is for such units and personnel and the corresponding amount of requirement as are furnished hereunder. But salary grant is A 1461 lakhs so and so for all the teaching staff. But I have specifically pleaded that this included my pay as a teaching staff, which has not been denied by the university. Please see the next page, where there is a segregation of teaching staff, non-teaching staff, and various firms. I say this included my pay as a teacher.
Yes.
So, I'm not having taken your lordship through the chronology of events, there was a conscious decision taken by the government on application of mine to the government memo, my representation, the UBKV's recommendation, and all documents available on record to come to a conscious conclusion that this gentleman is entitled to this upgradation because policy, and even in BCKV he would have got this entitlement. And he should not be made to lose by reason of his transfer during the nascent period of this transitory period of UBKV being formed. Now, this being the position, that I just showed to your lordship not two provisions of the act which really stops the UBKV even, far less the vice chancellor in his individual capacity to negate the decision of the government. But he is bound by the decision of the government. And I shall address your lordship on two aspects. One is the government's decision, the other is lack of quorum. Because these are the two principal points. Please take section 11 first. Powers and duties of the Executive Council, section 11.
Yes.
And it takes M for Madras.
Yes.
To approve the recommendations for appointment of officers, teachers, and non-teaching staff in the manner prescribed. M. To create posts of teachers, officers, and non-teaching staff with the approval of the state government. That's the power of the Executive Council.
No, regarding specific power of upgradation, no such.
Upgradation doesn't. Kindly see G may have some. G may have some relevance.
Make financial provisions.
For the instruction, teaching, research, that's general. But so far as not creating posts and then please see N. To sanction the increase of pay, allowances, and financial benefits to an employee of the university with the prior approval of the state government.
Yes.
L, M, and N.
Yes.
So exercise of power under sections 11M and N is writ large on the face of the record. Factually, by reason of a recommendation having been first made to the state government, secondly, the government having granted its approval, and thereafter the executive council decided to implement. But once there has been a recommendation, application of mind, no objection, approval and implementation, then it's a concrete action which is wholesome and matter comes to an end. There can be no reopening of the issue. Otherwise, there will be a never ending. Not somebody likes me, somebody does not like me. It will be depending on a never ending exercise. Then please see section 57 of the Act. Sorry, section 56. That was also referred to in the order.
Yes.
Section 56. Transfer of certain employees to the university. As soon as may be after the appointed date, the state government may, in consultation with the Vice Chancellor, direct by general or special order that such of the employees of the state government as are specified in the order shall be transferred to the university with effect from such date as may be mentioned therein. This does not apply to me. This is really deputation of state government employees. 2. The state government may, in consultation with the Vice Chancellor, request the former university means the BCKB as defined in this Act, to depute by order such employees of the former university temporarily to the university for initial establishment and for such period as may be specified in the order.
Yes.
Provided that no such order shall be issued in respect of any employee without the consent of such employee. 3. The employees referred to in subsection 1 and subsection 2 shall hold office under the university subject to such terms and conditions, not being less advantageous than what they were entitled to immediately before the day of transfer of or deputation, as the case may be, to the university, as may be determined by the university by statutes. So that this wait with the mind of the government. Then please see 57. Every employee who immediately before the appointed date was employed in the North Bengal campus, regional research stations and substations of Hill and Old Alluvial Zone and Krishi Vigyan Kendra at Kalimpong of the former university shall, on and from the appointed day, be the employee of the university and shall cease to be an employee of the former university. Provided that such employee may exercise option for his retention by the former university, and thereupon the former university shall absorb such employee in the vacant post of the same category, if any, in the former university. So the idea is to push them to the new university. Provided further that the employees who have exercised option under the first proviso shall continue to remain to be the employees of the former university and shall be treated to be on deputation. 2A. The process of absorption of the employees of the former university exercising option under the proviso to subsection 1 in the vacant posts in the former university shall remain open for such period not exceeding 5 months. But we are not on that. Straightway comes to 57(6). The seniority of teachers, officers, and non-teaching employees of the former university after transfer to the university shall be determined after calculating the years of recognized services rendered by such teachers, officers, and non-teaching employees in the former university before such transfer in identical posts or cadres.
Yes.
So these wait with the mind.
Seniority was also not happened.
So it was continuously treated to be 22 years of service. Had he been in BCKV, like his colleagues, he would have got this benefit. He possesses all these qualifications, so it can be done, although it is a first case of nature. There, that was the foundational basis for the state government to give its no objection. Then please see 57(11). The state government may by order issue any clarification or give any direction for giving effect to the provisions of this Act. But when the Vice Chancellor reverted me back to the post of technical superintendent, I approached the government for clarification under 57(11). Government said, no, this is not to be done. This is not really power invocable under section 5711. It was not a clarification required at all. But I shall also place that order for your lordship, sir. That is at page 205 of the writ petition. Written copy of note I believe has been handed over. There is a 2-page better copy which was handed over to the court by my learned friend.
Yes.
And it takes paragraph 4 of that document, of that order.
Got it.
Both the parties submitted their views and various documents related with the representation of Dr. Ghoshal dated 6th May 2015. The petitioner had joined BCKV in 1986 as technical assistant. Dr. Ghoshal did not exercise his option for retention by BCKV as per first proviso to 57(1). In this context, it is pertinent to mention here that the UBKV has been established by the UBKV Act 2000. Before coming into force of the said Act, the then existing employees of the BCKV were guided by the BCKV Act 1974. Dr. Ghoshal has obtained PhD in the year 2004 and made his first application for teaching in the year 2005, much after the establishment of the UBKV. Dr. Ghoshal was redesignated and upgraded to the rank of lecturer by provisional order dated 14 September 2009, subject to approval of the Executive Council post facto. The Vice Chancellor of UBKV, by its order of 13th April 2015, please see, after 2009, all that episode of 2010 UBKV Executive Council deciding in my favor, all these have gone to the backstage or probably lost sight of. The VC reverted Dr. Ghoshal to his earlier post of superintendent in the cadre of non-teaching employee from the redesignated and upgraded rank of lecturer. The decision to grant Dr. Ghoshal 2 advance increments for acquiring PhD degree was also withdrawn by the said order. The said order dated 13th April 2015 also states that a non-teaching staff cannot be treated as a teacher in the name of upgradation and redesignation without resorting to any proper selection process. The qualification attached to a teaching post is not the same as that of a non-teaching post. By dint of an order, a non-teaching post cannot be converted into a teaching post. In other words, approval of the highest level is missing in the facts of the present case. The Vice Chancellor of the UBKV in his response dated 23rd February 2016 to the representation of Dr. Ghoshal denied that the Executive Council had approved the redesignation and upgradation of Dr. Ghoshal as a lecturer. This is contrary to records. I have shown to your lordship the PC resolutions.
Yes.
It is observed, now this is the observation of the government. It is observed that section 57 of UBKV Act is related with transfer of employees and protection of their interest during transition in between the newly established UBKV and the former university. Hence, the provision of section 57(11) is not applicable to Dr. Ghoshal's claim. So, clarification was not required. Now, after hearing and careful consideration of the facts of the present case and on the basis of various documents, provisions of UBKV Act, other relevant provisions related to the representation, dated so and so, it is found that Dr. Ghoshal's representation has no merit and the same is hereby rejected. So 57(11) was not required to be invoked. That could be the only provision, because if the government does not have jurisdiction to decide, it was not deciding on merit of my claim. Now, please take what is the law relating to quorum in regard to this particular university? Quorum of the Executive Council.
Yes.
Please take once again section 10. Of the Act.
Executive Council.
The Executive Council shall consist of the following members: A, ex officio members. Now, there are 8 ex officio members.
Yes.
Provided that if any of the members referred to in clauses 7 and 8 is for any reason unable to attend any meeting of the EC, he may depute an officer under his control. B, nominated members. 1, 2, 3, 4, 5. 5 nominated members.
Yes.
So it's 8 plus 5, 13.
13.
C, elected members. 3 regularly appointed full-time teachers. So 13 plus 3 comes to 16.
Yes.
1 member of the non-teaching staff. 17. 1 regular postgraduate student to be elected. 18.
Total 18.
Total is 18.
Yes.
Then kindly takes what is quorum? 10, 5.
18.
1/3 of the total members of the total number of members of the executive council plus 1 shall be a quorum for a meeting of the executive council. So 1/3 of 18 is 6 plus 1, 7.
7.
7. But I have shown to your lordship there were 9 members present in that particular meeting of that is when it was ultimately confirmed.
Approved. Ultimately approved.
Now, please also see section 22.
Yes.
No act or proceeding of any authority or body of the university. That will also include the executive council. So no act or proceeding of executive council shall be invalid merely by reason of the existence of a vacancy or vacancies among its members or by reason of any person having taken part in proceedings is subsequently found not to have been entitled to do so. So if there is vacancy in the EC, so by reason of vacancy of the chair, the decision taken by the executive council will not become void. Or if somebody has taken a decision and it is later found that this gentleman was not capable of holding the post of member of the executive council or any other post in the university, then the decision will not be void. But here is the case, at no point of time the executive council had the full strength of 18 members. Please have a look not to page 8 of my affidavit in reply. And this is apart from the fact that there were 9 members present on that particular date. Page 8, the last paragraph, second paragraph. I say that the governing body, that the government had already given its no objection for my upgradation or redesignation as lecturer. The 40th and 41st EC meetings were scheduled after the government approval. The same are really insignificant. The order of 24th of August 2009 upgrading me as lecturer from 1/6/2008 and on provisional basis ought to be treated as final in the teeth of the government approval already granted towards that end. The government had not granted any provisional approval in this regard. The approval of the government was conscious, distinct, and final. UBKV had no jurisdiction to disregard or challenge the decision of the government in this regard. It is stated that executive council meetings were held in quorum in terms of section 10(5) of the UBKV Act. Such provision requires the presence of 1/3 plus 1 EC member to form a quorum. It is stated that from the first meeting of the executive council held on 16 September 2001 till at least the 42nd EC meeting, there had never been full strength of executive council members. The total number of members of the EC had never been in its total or full strength. As per section 10(1) of the UBKV Act, comprised an executive council full strength can be of 20 members. However, as on 42nd executive council meeting held on 10th April 2010, the total strength of the executive council was 12 and comprised of the following members. These are the 12 members named. The posts which remained vacant were regular registrar. 2. Agro-industrialist nominee, Government of West Bengal. 3. Dean Faculty of Agricultural Engineering. 4. Director of Research. 5. Director of Firms. 6. Director of Extension Education. 7. Students representative. 8. 1 teachers representative. Therefore, the quorum in the context of the existing strength of the Executive Council would mean 1/3 of 12 plus 1, that is 5 members. On the admission of the respondents, there were 5 members present in the 42nd meeting of the Executive Council held on 10th April 2010. Subsequent government orders of 8th February 2010 and 20th April 2010 as regards formation of quorum of the Executive Council through its 8 members was obviously not on the basis of the existing strength of the Executive Council members. In any event, the government's letter of 2010 had not decided any issue adversely against the 40th, 41st and 42nd Executive Council meetings. The government had made calculation on the basis of 20 members as stated in the UBKV statutes, whereas actual number of members in Executive Council was less than 20 till establishment of UBKV. Existence of 20 members was artificial and unnatural. It will mean that when there are not less than 20 members, the quorum would be calculated on a notional basis in view of existing members, which was 12 in the 42nd meeting. So there was vacancy.
Yes.
And the Vice Chancellor was writing that he was waiting for convalescent members, he was awaiting favorable persons to attend the meeting. Neither here nor there. Who are the persons? Why so? How could I have ever influenced the government even? Remember that particular section where it says that the powers of the EC, powers and duties of EC. '57, no.
Section 11 is the power of
Yes,
executive.
I'm sorry. 11, L and M. Please see once again the opening language of section 11. Powers and duties of the Executive Council. The Executive Council shall exercise the following powers and perform the following duties. Shall exercise the following powers and perform the following duties. Please turn over to M now. To create posts of teachers, officers, and non-teaching staff with the approval of the state government.
Yes.
N. To sanction the increase of pay, allowances, or financial benefits to an employee of the university with the prior approval of the state government. So who is superior in terms of 11(1), M and N? It's the state government. Without the state government's nod, you can't do anything. And it's shall, you'll have to do this duty. You have to perform this exercise with the approval of the state government. There is no, can the EC say, although the state government has given its nod or given its sanction, I will not grant.
Yes.
But what is the process of approval? If I may just not leaving aside all these rigmarole of, but administratively, I put something before a table for approval. So when I lay a note for approval, there is already on record an application of mind or a proposal. Approval is not granted in the air. There is something material which has to be approved. So the first application of mind comes from the university. It goes to the state government for approval. The state government approves and then the implementation. When 11(1) M and N speaks of shall perform this duty, it is once the complete exercise of mind is complete. Then it's implementation. It's really in the nature of implementation after the approval. So once implemented, it cannot be reverted back. That's my point. And apropos the Executive Council of the university,
Yes.
and the state government, the superiority lies with the state government.
What was the order of the state government after the writ application?
That's the page 205, that 2-page better copy that I read out. Paragraph 4 onwards I read out, that's 27, that's the one. It is at page 205 and 206 of the writ petition, not very happily legible. It says that 5711 cannot be invoked.
The 5711 is a different issue.
That's a different issue. My client sought for clarification, the government said it's not a clarificatory issue at all.
Right.
So this reversion order is absolutely bad, contrary to section 11, number 1. Number 2, it really attacks university's own decision.
Yes.
And a decision once implemented gives rise to a vested right.
Decision implemented by virtue of the order of the government.
It has given rise to a vested right.
Yes.
And the effect is a retrospective curtailment of a vested right. These are my submissions.
Yes.
Therefore, not this order should go, and not my client should be allowed the benefit in terms of. But in fact, if your lordship kindly recollects the order of the vice chancellor, it says the EC meetings were set at rest by the government. If he was conscious of the fact that the EC meetings decisions were set at rest by the government, how could you sit in appeal over the government's order then? Lordship will kindly fix a date for us to give the reply. Wednesday, if your lordship kindly fixes it at 2 p.m., we'll complete our submission.
Wednesday, I am taking the read matters.
Yes.
Other read matters are they are pending read matters. I am fixing the matter, important matter on the separate dates, except Wednesday.
Thursday, Friday, any day convenient to your
Thursday, I
lordship.
have other determinations.
Any day convenient to your lordship.
So this Friday,
Friday.
the argument on behalf of the petitioner concludes. Matter is heard in court. That the matter fixed on 22nd of September 2022 for argument on behalf of the university
2 p.m. your lordship.
at 2 p.m.
Great.
Special fixed matter. এর ভিতরে রাখবেন, হ্যাঁ? 35. Yes. This goes. You are the appellant in this matter? Yes.
Or for report from the people, hospital nurses. That has been received from hospitals. The nurse is also appointed an advocate through legal agencies. The appearance was waiting for that.
No report has received.
It's last question I asked the nurses, they made, initially, Mona has nurses admitted in hospital and everything, every document lying with the owner. And owner did not proceed in contest the case. He is not lordships come before under tribunal or as well as for your lordship, then it is presumed lordship. But no contrary evidence is also there. If I ask what happened, everything is lying with the owner. A few documents with that has been submitted. And lots of several times notice has and we said presumption may be considered. Yeah. One 4 because it is also
himself present and criminal case made it's a bail bond also and take his vehicle also. After made FIR, then that's it submitted.
So the vehicle was not in CO.
Vehicle was not in suit. I'm claiming lordship against owner. Lordship is not a
I understand.
everything is no.
If you-
knowledge of owner lordship.
If you have the order,
Yes.
so how can you recover the same?
Recover was a contact. Your lordship several attempts taken away. Your lordship say notice, arts lordship also 2 times and notice everything. And one advocate also called me. Lordship. It is a number of compromise with the payment. These are the things. Later it did not respond. You are not paying one.
Come on tomorrow, where is Anita Khet?
Lordship. Was waiting until lordship I respond.
Come on tomorrow. Not today. Please take down. The order was served upon the superintendent and NS Medical College. No report received yet. Let the matter be fixed tomorrow for further review.
And 37.
Produce the case date.
Yes. It is regarding the non-involvement of the vehicle. Is that this case?
That's dismissed by the appellant.
Yes, Mrs. Paul,
Lordship.
this issue is in respect of FIR.
Yes, Lordship. The FIR, it was delayed by Lordship 75 days.
Yes.
And first time the number it came up in the FIR and the vehicle was seized there. Suthal report, it spoke about
Yes.
unknown vehicle.
PM report or Shrothal.
Suthal report. Suthal report. It's a exhibit. It's there in the paper book. It's page 67.
Just after folded page.
And it says that police was informed by the doctor.
The report, the name of the disease appeared. Rajesh Sampasi. Have you got it? Page 67 of the bottom.
Yes.
The date of death. The inquest report. But when the deceased name is appearing.
There's no dispute regarding the death of the victim. It's only whether this particular,
Name is appearing on that date of inception.
very fine, but it's only regarding whether this vehicle was involved or not.
After that, the wife has lodged a complaint after 75 days, according to my learned sister. So, Planet Tribunal satisfied that the FIR lodged related stage, but is satisfied. There's the observation also appearing in the judgment.
It is in the inquest report that the
Yes.
Adesham Pasi was accident by unknown vehicle.
Yes, Lordship.
This is the question.
This is the page 68.
Yes.
And therefore, it was observed, hence I submitted FR of the case. If any clue who occurred in near future, the case may be reopened.
Yes.
That is at page 68.
So, we got the
So my entire case is on this, and it was lodged after 75 days, and the explanation given in the written complaint.
Will you also kindly go to kindly see the CD that?
Yes, yes.
Yes, yes.
To controversy.
Page 6 and 7 is the eyewitness. Also, you find the number, the same multiple. Image 04A07 itself. Sadok Bauri and Roy is the eyewitness of the incident. Yes. This is regarding the involvement. And anything?
Yes,
Because of the margin number prior to submission of this report, is the involvement part satisfied?
I will pass the order, no issue. Let me hear about the appeal.
The next question is Lordship quantum. So we can argue jointly, no issue, because we have discussed the issue. Because of the quantum, Planet Tribunal also considered.
I have some submissions to make.
Yes.
Let him finish.
No, who is the appellant?
I am the applicant.
Yes, you just start.
After this point of involvement, if it goes, Lordship, after that, I'll come to his cross that my learned friend has prepared, Lordship. The cross, Lordship, there's one condonation of delay, Can 1 of 2023. Lordship will kindly come to that condonation of delay application of my learned friend.
Page.
No, it's the condonation of delay application, which he has
It's a court.
of the court preferred by my learned friend. Can 1 of 2023.
Yes.
Yes. Now, Lordship will kindly come to page 3, Lordship. Page 3, paragraph 5.
Yes.
Your applicant states that no notice of appeal has yet been received by the claimant's respondent. Now, my learned friend's court is numbered at court number 77 of 2022. Now, on 10th of February 2017, Lordship, my learned friend had withdrawn 50%. So how can he say that after receiving the money, he doesn't have any notice of appeal? Number one. And this court, it has been filed with a delay of Lordship 1238 days. Lordship will kindly come to the next page, paragraph 6. Your applicant states that during the pandemic situation, he had withdrawn the money in 2017, 50%. Now, pandemic situation.
Yes.
Same in paragraph 7. It's your applicant submit that from March 2020 till the year of 2021, the pandemic situation was going on. Subsequently, also it was going on with a very restricted manner. Usual. I vehemently object, Lordship.
Yes.
To this. Lordship will kindly not allow the court, even if the point of non-involvement, if it goes, Lordship will kindly not allow the court and it will restrict it to only what has been awarded, Lordship. A lump sum amount of 15 lakh was awarded. Lordship will kindly restrict it to that. This is my submission, Lordship. That's it. And lump sum amount of 15 lakh and 6% interest. You withdraw the money in 2017 and you come up in cross in 2022 and you say that I don't have any notice of appeal.
Yes.
That is all, Lordship. কিছু জানি না। Junior.
Yes, Mr. Rai.
That's the ground which I have stated in my application for conversion delay. Prior to that, lawsuit, I placed the appeal, the judgment under challenge. Judgment ultimately under challenge. So can you come to the challenge? Certainly, I answered the lawsuit.
I'm sorry, just once more, I'm sorry, Dada, Akbar, just talk about.
Yes, yes.
Just I shouldn't forget this. I'll just give two judgments, one judgment, Lordship. It take to my lord. I'm so sorry, Lordship. I'm bole dichi. 2012, 5 SCC, 157. I'm bole dichi. Lordship, this is on limitation, Lordship. It's of course on section 5. I rely on the head note, Lordship, which says that expression sufficient cause. It's regarding, this entire judgment is regarding sufficient cause.
Yes.
That if there is sufficient cause, then definitely the delay should be condoned. But if in case of in case there is no sufficient cause, Lordship, no leniency should be shown. This entire judgment is on that. I am not reading further, Lordship. I rely on the head note and also the entire judgment.
Yes.
Lordship, I am deeply obliged. লিখেছেন, লিখে নিয়েছেন? আমি দিয়ে দিচ্ছি আপনাকে।
Also, can you come to the judgment? Judgment. Kindly come to page 75, in which judgment starts. He is for the appellant, but I am discharging the judge.
Yes.
The case has been arising out of application under section 166 to the motor vehicle and estate filed by the petitioner paying for compensation of rupees 28 lakhs. On account of 28 lakhs, he is deposited court fees. On account of death of Rajasthan Pashi, husband, son, father, then the petitioner. Petitioner case is that there is the case which are narrated because she was gone to the city, not required to refund fund. And losses second category is OP number 1, the registered owner of the vehicle, OP number 2, the National Insurance Company, OP number 1, Maruti van, after receiving the summons, appeared with the court by filing a written statement. So if and the subsequently did not contest, so adverse presumption make it wrong against the OP number 1 because of already printed appearance. It is not that the summons not been served, he did not appear. He appeared, filed written statement, after that did not contest. So adverse presumption can be drawn. Not required to place in his judgment or to say that. On the other hand, OP number 2 appeared, filing written statement, contested the case, tooth and nail, denying under there. Then also after that issue came, that issue also came, did the accident alleged occur due to rash and negligent driving on the registration number MH04A Maruti van? Did the Rajasthan Pashi die due to alleged accident due to the Maruti van? So that all the issues have been framed. The issues has been framed by the learned tribunal, means that all the issues answered by the learned tribunal after the submission considered by the respective parties. Then lordship, some judgment has been cited. They again narrate the fact. PW2, PW5 claimed as the eyewitness of the incident. They have said, yes, I have seen my own eyes the accident took place. The Maruti van is the offending vehicle due to the rash and negligent driving of the driver of the Maruti van. The accident took place.
Yes.
After that lawsuit, PwC Orcon Ghosh, representative of the ECL. That is the actual appeal as my appellant placed before lawsuit on the point of quantum. Orcon Ghosh, representing the ECL authority, brought paisley. This is Rajasthan Pashi, identified the same and has been marked exhibit 9 series in cross against the salary of the disease varies from month to month. The wife of the deceased Rajasthan Pashi was observed the due of this death. And then lordship kindly see one of the PW4, Amol Kumar Goswami, senior personal assistant to the agent of Icha Korea, who identified the payslip and Rajasthan Pashi for the period of June 2010 to May 2011 for the 1 year lordship.
Yes.
Which have been marked exhibit 10 and 10 to 10, 11. In cross examination, stated that the salary of the disease varies from month to month. Very well, month. Learned counsel for the following decision: the rash on the question of rash and negligence. And second judgment is 2003 SE 428 Karnataka. filing charge sheet against the driver is a prima facie case to hold that driver of the lorry was responsible for the accident, burden shifted upon him to prove that on that spot because of charge sheet submitted and lordship from the CD to charge sheet are now present before your lordship. And second point, lordship, GPA LIC, lordship also passed the judgment in such a way the GPA LIC cannot be reduced. That judgment also fails. That and so that the marriage, the deceased was married at the time of court defendant, so 1/4 has to be deducted. That is also lordship covered by lordship judgment. And 34 years old, so multiply should be 16. I believe it should be 16 or 15. So whatever will come in the schedule, lordship will consider the same. Subsequent employment with the compensation appointment, also lordship considered that cannot be deducted or cannot be considered, will not come under the purview of the just compensation allocation 166. That is also covered by lordship. And if the appears for the certificate FIR charge sheet, then lordship kindly see the learned counsel of insurance company. So it's the last paragraph, second paragraph from bottom. Learned counsel for the OP insurance company, when the FIR was lost since 2 months, 14 days incident after does not mean the claim is liable to be dismissed. And kindly see that the submission of the insurance company, OP no insurance company submitted that FIR was lost since after 2 months, 14 days of the incident, but does not mean the claim is liable to be dismissed when there is the explanation of delay mentioned in the FIR in view of the decision of the such and such cited by the learned lawyer for the petitioner wherein it was observed that delay lodging FIR cannot be a ground for rejecting the claim application. So they did not raise the issue, but ultimately did not raise the place the issue for consideration. Moreover, it is clear indicating the FIR exhibit to the duty to funeral ceremony and other ceremony related, and this is FIR was lost related. That explanation is not required to place because of lordship knows the criminal proceedings. That remains the burden of proof. Then lordship kindly forego this all paragraph. Then lordship kindly turn to page 78. Lordship 1, 2, 3, 4. 4 paragraph as regards. Got it? 70 page 70. As regards determination of quantum of compensation, I find the evidence of PW1 re-narrated of what has been stated in the petition. PW1 stated that at the time of accident, my husband used to earn rupees 25,000 per month from his service. PW3 and PW identified the payslip of the deceased Rajasthan Pashi Exhibit 9, Exhibit 10, which shows that the monthly salary of the deceased varies. Moreover, there is no evidence above witnessed the actual annual or monthly income of the deceased prior to his death. I am against that observation. I feel the appellant also against that observation because they are the both ground involvement as well as the quantum. He also appeal on that ground also. The actual gross income, monthly income, as some the payslip are eligible, from which it cannot be calculated or ascertained about the actual annual income of the deceased when there is no clear picture about the total actual annual income of the deceased. At the time of accident, a lump sum amount should be awarded by the compensation for the petitioner.
Now, what is the ground? Illegible.
Illegible. Because if it is true, some of the payslip is irrelevant. It's true. But whatever all the payslip are not irrelevant. For the reason, lordship kindly come next paragraph as well order. I fix the tribunal 15 lakhs the lump sum compensation due to the sudden accident. So lordship lump sum that observation is lordship last day also have shown from the judgment of Kajol where one judgment is deferred. Lump sum method cannot be the sound method, the multiply method, the sound method that has to be applied. But the learned tribunal did not apply that. Lordship, the appeal paper by the insurance company. I am putting the question before the law. So being a student of law, that under what circumstances learned tribunal, it may be not the learned, my sister already been submitted that whatever awarded by learned tribunal can it give them. My question is the award is less than that, then what will happen? So the cross examination is very much required. If I not play the cross examination, lordship is not the complete justice cannot be administered. For the reason I have placed the cross examination. And on my application, his raised dispute, the application for confirmation of delay in connection with the cross subsection, he has raised the dispute. The notice of appeal. The notice of appeal is a separate proceedings. Notice of appeal cannot be said that once I have appeared before the court of law, then lordship will say that once he is appeared before the appeal court, so service of notice will dispense with on his appearance. that order is not there. It is not that I did not file my record of the money. It is not that I have withdrawn the money. It is the record. How can I deny? Is there, but there is no observation. It's like that. The dispense with the service of notice dispense with upon the respondent on his appearance. That order is not there. That order is what to have required.
No,
On that
why
score-
you stated the otherwise in the court? Why you stated otherwise in the court? That is the objection.
No,
Why
no,
you stated otherwise in the
no.
court?
Very well. I have given the explanation, but that is the basically the appellant taken that the notice of appeal define that observation that my statement in such a way that the once is appeared, so notice of appeal is already is like notice of appeal. No, that is not like notice of appeal. Notice of appeal has to be issued even if appeared, but the notice of appeal has to be dispensed with on his appearance.
Yes, specific order is not there,
Specific
but
order-
you have
But
appeared
I
in this
admitted,
matter
but
earlier.
Lordship, I am admitted. But
Yes.
Lordship kindly see, otherwise, if the lump sum compensation has been awarded, on that score, Lordship, I have come. Lump sum compensation awarded, that's what I have come. And the judgment, Lordship kindly see, the judgment already I have cited before your Lordship in the case of Lordship Dipali Sarkar. But Lordship was pleased to that the CAV. Here, Lordship kindly see the after dismiss of the cross objection, the Supreme Court come to a conclusion. Lordship kindly come to a paragraph 4. It is down the belated stage. Lordship, insurance company was before the High Court, appealing the said hour, appellant no doubt. There is an appeal preferred by the
Did not file an appeal initially.
But however, have filed a cross objection in the appeal, which had been filed by the insurance company. However, delay in filing cross objection, the High Court through judgment let us dismiss the appeal as well as the cross objection. It is that the appellant are before the court in the appeal, having heard the counsel for the party, so the counsel for the insurance company contend that considering the enhancement would not be arrived in as much as cross objection being dismissed. That is the submission of the insurance company before the apex court. On the ground, the claimant enhancement being the made belatedly, we are of the opinion when the just compensation required to be determined, the technicality in regard should not be come in the way of the appellant. That is the specific define the case. And the judgment as referred by my learned sister is the 2012. That I have retired my submission once and again. That the after Punoi Shetty, after 2017, asked them to place a single judgment where the Supreme Court did not adhere to pass the judgment without considering the Punoi Shetty. But a single judgment he asked him to place, then I have no case. But nobody can place a single case before of the apex court after the Punoi Shetty with that ground. But the mere technicality. So after that, Lordship kindly found that the 30% future prospect has been already been granted in this judgment. In the year of 2012, that conception was not there. But the conception was there. But all the judgment was not come under the Article 141. Yeah, Lordship will found in the Punoi Shetty case, first line under Article 141 is a 5 judges bench. After determining the compensation, how to determine by the tribunal, the dictated by the dictum of the apex court cannot be ignored. It's true that it is true, Lordship. So of the record, I am submitting the explanation which I have given. It may not be sufficient. But unless and until Lordship will consider my cross objection, the grounds, Lordship kindly see what are the grounds which I have taken. What ground I have taken? Can you kindly see? That is the ground within the periphery of the observation of the learned tribunal. The learned tribunal assessed the just compensation by considering marking 25,000. And then what I have taken a ground, the lump sum method should not be, and Lordship also knows the judgment, lump sum method should not be. And Lordship, I have also stated that the future prospect. That is the. So Lordship will confirm the observation of the learned tribunal. There is a lump sum method applied by the in spite of the cross objection has been filed. It is filed belated stage. That's true. But what about the explain? What about the what the reason? As said by my client that I have. They said there is a such problem. I did not attend your office or I did not meet with the learned advocate due to the SARS regime. In between, COVID-19 was gone. That is the reason. So only the mere technicalities is not filed in time, or in spite of that, the notice of it did not serve. That is also a technical issue. Once I have appeared, notice of it did not issue. It doesn't mean that I have not noticed that the appeal has been filed. So I cannot take that plea. The notice of it did not serve upon me. That is also a technical issue that I cannot that I can forgo. Basically, balance the convenience, inconvenience of the justice. So notice of appeal not yet served. That is also a technical issue. Once I have appeared, and lordship kindly see the first order. Once I have appeared, and the service of notice of appeal is dispensed with upon the owner. Lordship kindly see the first order. That dispensation is there. They appeared, they have submitted the notice of service of notice of appeal is dispensed with upon the owner. That dispensation that was there. But that technical issue, if I am ready to follow, that there is no technical issue, but the conservation not filing in time. It's the same thing, and that is the technical issue. Obviously, the technical issue that is affirmed by the Supreme Court. The technicality in regard should not become in the way of the appellant.
Yes, hard.
So my humble submission, Lordship, one thing is regard to the submit. The Lordship kindly see that I will take the assistance of my my learned assistant. Please take to it. So Lordship kindly see, kindly just assist the ultimately whatever the papers will come before the learned tribunal, at least learned tribunal go through the same whatever is practicable, as far as practicable. Just kindly come to paragraph folded page 37. Kindly, Lordship. It is very I Lordship kindly pardon me, Lordship. And Lordship, the record before your Lordship. Lordship kindly see the record from that, then it will serve the purpose ultimately. Otherwise, I cannot overcome the situation.
Yes.
Kindly see this 37 is the income is Lordship 20,000.
Yes.
And then Lordship kindly come to case 38, income is Lordship 19,030. Is the net income Lordship. Gross income is more than that. It is very tough job. Well, I believe. But Lordship, to that extent I have identified net 39, 23,430 is the net income. Is all I am submitting the net income. Gross income is Lordship 25,000. Page 39, Lordship will found the gross income is 25,000.
This is for the month of?
This is for the month. Very difficult to certain Lordship, even then I am trying.
The right side corner up.
Right side corner. Yes.
First page is the January 11, second page is the February 11, third page is the March 11.
Yes, Lordship. It is because I have with the photocopy of that that photocopy is so illegible. But that is the original copy before your Lordship. Whereas Lordship can ascertain. I pardon, but Lordship will do the same. Otherwise, I cannot. My duty to assist the court by unable to do the same, and I also pardon on that score. But Lordship, so Lordship, he is the 50% future prospectus entitled and 70,000 general damages. That is the cross of it.
Okay.
Or Lordship will affirm the judgment of the tribunal. There is also the lump sum that method will be Lordship will affirm. Such cannot be possible. It's beyond the judgment of the apex court.
No, my lord will keep this one, this case diary.
Case diary with me.
That's the original one.
Okay, I have already seen. I will return it. Give me the copy.
Yes.
Lordship, in just one or two lines, may I, Lordship, in reply to his technicalities and cross objection, Lordship? Just one or two lines, Lordship.
Yes, you have the right to do that. Let him finish first. Let me see whether.
Yes, Lordship, that is my submission. So kindly allow my cross objection. If Lordship, there is no my sufficient court, if Lordship, and my humble submission, my very humble submission that Lordship, unless and until Lordship allow this my cross objection, the petitioner will suffer irreparable loss.
Very good.
I am deeply lost.
No, my lord, our appearance.
Yes, yes. Yes.
Unless
Very
some payslips
You are
are
released. No
with
issue.
me, may I handing over that? That some payslips are with me. It is very busy.
I have the visible pages.
Exhibit হচ্ছে, exhibit হচ্ছে।
Yes, anything?
Yes, আর তো কিছু বলবো না। ওই
না, থাকলে আছে।
আচ্ছা। মানে বলে দেবো?
বললে তো আমি বলছি।
Lordship, regarding this condonation or delay, Lordship, he was in knowledge that this appeal has been filed. He has withdrawn the money. So this technicality issue regarding this notice of appeal, it's not applicable in this case, Lordship. So he was
That
very,
was not my submission.
Lordship,
That
then
was
let him
not-
submit, then I'll submit. I'm
That
sitting
was
down.
not my submission. My submission
yes.
was.
You,
that
Mr.
he-
Mr.
Lordship, my submission
Later,
was.
I know you. I know you, sir.
Yes. But his reply, that is was my submission.
No,
That's
no.
the reply.
Let
With
her,
the instruction
let
of
her
Mr.
argue.
Singh,
Let
that is
her
the
argue.
basic problem.
Let her argue.
Mr. Singh also understands wrong and she also prompting the wrong.
No, Mr. Singh is not here.
Lordship,
No, no,
Lordship will
why?
kindly let, I'm being led by Mr.
No,
Singh.
no, that is not permissible. That is not permissible. Lordship will apply this way. Why is that? He is continuously prompting. Why he is prompting?
I'm being led by Mr. Singh.
No, no,
Yes.
Why is led by?
Why is he afraid?
And
No,
the
no.
end of the case is led by.
This issue cannot be decided like that.
So Lordship ask him to
This
take
issue
his
is
seat.
separate.
Let him give reply, Lordship.
So let him to stop.
No. He can.
Why
dictate.
not?
I'm being led by
He is not arguing in this matter.
Very well, Lordship. He will argue, then I'll argue.
He is not arguing in this matter. Mr. Singh is not arguing in this matter.
What will do?
Mr. Singh, Mrs. Paul is arguing.
Yes, let him allow him to argue after.
Why
the
is he
judge
afraid, Lordship? It's a general issue. It can be dealt with by Mr.
Allow
Singh.
Mr. Paul first. After that, if not, then Mr. Singh will come. Very
No,
well.
why
This is
you are so, why you are so.
No,
Why is he so adamant
No,
and
no.
afraid?
Afraid. I'm really, no, that practice I will not allow.
I will not allow.
I will not allow.
Yes.
Oh, very well. Yes. Mr. Please sit.
Of
Let
country
me
that
hear
should
the
go
issue.
support. I do not know why Applicant Miller wants to run away from them.
No,
Why my name
nobody's
is
run
not
away.
at all?
Nobody's run away. Nobody's run away. Your apprehension is absolutely wrong. Wrong impression. You have run away to the court. Please take your seat. I believe.
No, I have asked the order, no issue. Today will say. You are released, no issue. You are released.
Condonation of delay, Lordship, it's absolutely false statement. Blatant false statement.
Yes.
This sort of condonation of delay application, Lordship, will kindly not allow, Lordship, because this will give a wrong notion. I take the money, I come back, and then I say that because of COVID-19, which is in the year 2020, I withdraw the money in 2017. And I say that I don't have any knowledge of the notice of appeal. I was not served the notice of appeal. I don't have any knowledge, but I have the knowledge that the appeal was filed and I can withdraw the money. Lordship will kindly dismiss this sort of false condonation of delay application. Absolutely blatant and false statement. And then he is afraid, and then he is taking the name of Mr. Singh. I am being led by Mr. Singh in every matter. We all are being led by him. And it's an honor to be led by him.
Just one line, just I am submitting that technical issue, notice of appeal, that order was not there. I am ready to forgo this issue. Accordingly, you have the judgment as I referred to the lordship. That is also said, that is the technical issue. The cross appeal is not there, even then he is delegated. In absence of cross objection, the point is dismissed. Even then, punishment is applicable under order for the Article 141 of the Constitutional Rights. That was my submission.
Well. Please take down. instant appeal is preferred against the judgment dated dated 30th March 2015, passed by the learned judge, Motor Accident Claim Tribunal, First Court, Asansol, in MSC case number 40 of 2012. Stop. The brief fact of the case is that the present respondents, being the petitioners, preferred an application to the learned tribunal for getting compensation on the ground that their predecessor was died in a road traffic accident due to rash and negligent driving of the driver of the offending vehicle, duly insured under the policy of the insurance company. Stop. The matter was contested by the insurance company, and after hearing both the parties, the learned tribunal has ordered a lump sum amount of rupees 15 lakh along with 6%. Along with 6% interest per annum from the date of application. Being agreed by and dissatisfied with the said order, the insurance company has preferred this appeal. The first ground was raised by the insurance company is that the entire case which was stated by entire case and the manner of accident which was stated by the before the learned tribunal is erroneous. Stop. The so-called offending vehicle, that is the Maruti vehicle, insured by the insurance company, is not involved in the said accident. Stop. Learned advocate insurance company further argued that from the record it would be revealed that the FIR was lodged after the 75 days of accident, and the inquest conducted by the police over the dead body disclosed the statement of available witnesses who stated that the deceased was dashed by an unknown vehicle. Stop. The CD was called for the advocate appearing on behalf of the state. Learned advocate appearing on behalf of the state submitted the CD. Peruse the CD. It is true that the alleged accident was held on 9/6/2011, happened, and the FIR was filed on 23rd of August 2011. Stop. The copy of inquest is placed with the CD. At the time of inquest, the police officer who conducted inquest under section 174 of CRPC has made a statement that the near about persons told about the accident that the deceased was dashed by an unknown vehicle. During the perusal of the CD, it appears that after the police case was started after 75 days, police has reached near the reached at the PO, and some statement of the witnesses were recorded. Some of the witnesses stated that the deceased died due to the road traffic accident, but could not say the name of the vehicle who dashed, name of the number of the vehicle who dashed the deceased, but some statement was also there in the CD regarding the number of the offending vehicle stopped. The statement of the owner was also recorded by the IO during the course of investigation, wherein the IO has, wherein the owner has disclosed that the the offending vehicle owned by him was suffered an accident by which one person was dead. So the technical report appeared in the CD also disclosed that right side front headlight was broken, and it is the opinion of the technical expert that due to the accident such light can be broken. Considering the entire facts and circumstances, it appears to me that the issue of involvement of the vehicle in the alleged accident raised by the insurance company as specifically observed, and it is ordered that the issue is not justifiable to be entertained. The original CD is here ready. The next issue, the insurance company has submitted that the quantum of compensation cannot be enhanced at this stage by virtue of an court by virtue and cross appeal filed by the claimant. Stop. The claimant has filed a court cross appeal being court 77 of 2022. Stop. Admittedly, the instant appeal was preferred in the year 2016 and the court was preferred in the year 2022. There are delay of 1238 days in preferring the court application. The condonation of delay one can 1 of 2023 was filed. Learned advocate for the respondent claimant submits that the delay in preferring the instant court application is unintentional. And the delay caused due to the ignorance of law by the claimants, so the delay may be converted. The court application and the cross objection may be treated to be heard along with the instant appeal. The learned advocate appearing on behalf of the state and on behalf of the insurance company raised strong objection and placed his reliance upon some paragraphs, that is paragraph 5 and paragraph 6 of the Can 1 of 2023. So it has been stated in the said paragraphs that the applicants had not received any notice of appeal, and due to the COVID pandemic, they were not in a position to file the cross application in due time. However, the learned advocate for the insurance company argued heavily on the point that in the year 2017, the claimant has appeared before this learned court and received the 50% of the awarded amount, which was deposited before the learned Registrar High Court Calcutta. On that score, she argued that the statement made in the CAN application is not at all true, and on the basis of the said untrue statement, the limited application under Section 5 of Limitation Act cannot be. In support of his contentions, he cited a decision reported in reported in 2012, 5 SCC 157. He referred the decision to show that when the application for limitation doesn't have the ingredients of sufficient cause, the application cannot be allowed. He argued that in the instant case, the leniency cannot be shown to the claimants for condonation of delay, while the itself application that is the CAN is filed with wrong statement. So he paid for rejection of the CAN application along with the court. Stop. The learned advocate appearing on behalf of the claimant respondent submits that the issue of rejection of court was appeared before the Honorable Supreme Court in Sandeep Juneja versus National Insurance Company Limited, reported in 2023 to TSC 716 within bracket S. He referred to paragraph 4 of the said judgment. The paragraph 4 of the said citation is said as hereunder. Stop. He argued that the Honorable Apex Court is of view that that in awarding the just and proper compensation, the technicalities should not be looked into. He argued that the court was filed only for getting the true just and proper compensation. The Honorable Supreme Court in Pranayati has observed that in all pending claim application and appeals, the claimants are entitled to get the future prospects as well as the general. This is a pending application. Though if the court may not be filed, but the claimants are entitled to get the just and proper compensation by this appellate court by awarding future prospects and general damages according to the observation of honors. Had the learned advocate perused the observation of the Honorable Supreme Court in several issues. It is true that the statement in the CAN 1 of 2023 cannot be taken to be true in respect to the attending facts and circumstances of this particular case. The application under Section 5 of Limitation Act is filed basically for condonation of delay. When the sufficient cause was found, the leniency has to be given to the petitioner. The petitioner must have shown how he was prevented for not filing the appropriate application within the statutory period. The cross appeal was preferred, much delay after the filing the appeal. So, considering the entire statement and the facts and circumstances of this case, I think the CAN 1 of 2023 has not stated the sufficient cause or the cause shown by the petitioner in the instant CAN application cannot be allowed at this stage. Thus, the application under application for condonation of delay for filing the cross objection under Order 20 under Order 41 CPC is hereby considered disallowed. In considering the just and proper compensation of this case, it appears to me that next part, the learned tribunal has awarded a sum of rupees 15 lakh in a lump sum way along with 6% interest per annum. Stop. The learned tribunal has observed that the deceased was earning rupees 25, was earning deceased was no deceased was a earning member of the family who was in service with the
Page 4 of the award, Lordship. Page 77.
yes
Okay, perfect.
with Coal India. He was employed in the Coal India and Eastern Coalfield Limited. Eastern Coalfield Limited. And the claim application was filed to with the statement that he used to earn rupees 25,000 per month. The learned tribunal, some pay slips were produced before the learned tribunal and were exhibited through the witnesses. But learned tribunal has not correctly ascertained the writings and the words in the payslip. Thus, he is of view that these are illegible one and cannot be accepted. Thus, a lump sum amount was given. I have perused the LCR. It appears to me that the several payslips were filed, but some of them were illegible and some of them are actually legible. Very surprisingly, in observing, very surprisingly, in observing those pay slips, it appears to me that the gross pay of the deceased for the January 2011 was 20,856, while in February it was 29,000. And March 2011 it appears 39,000. And in the April 2010 it was 33,000. Furthermore, in the January 2010 the gross pay was 17,000. The gross pay including the family pensions, professional tax, pension scheme, income tax, etc. to be the deduction part. Stop. So it appears to me that the ultimate conclusion of the income of the deceased cannot be possible. Stop. Stop. It is proved that the employee, that is it is proved that the deceased was the permanent employee, and he used to earn monthly by receiving the pay slips. Considering the entire evidence on record regarding the pay slips, the monthly income of the deceased can be safely calculated to be 20,000 after deduction from professional tax and income tax. Next one. learned tribunal has awarded a lump sum amount which appears to be improper. The learned tribunal should have passed an order of compensation with the with adopting a structure formula according to the provisions according to the law laid down in the stop. Considering the same, it appears to be the impugn order passed by the learned tribunal each need be modified. The just and proper compensation it comes to rupees. It assessed here. The monthly income of the deceased comes to rupees 20,000. The yearly income comes to rupees 2,40,000. The 1/4 is deducted towards his personal expenses as the number of claimants are 4. So after deducting 60,000 towards the personal expenses, the yearly dependence comes to rupees 1,80,000. Stop. The the claimant was involved in a permanent job. So according to the direction of Pranay Sethi, he is entitled to get the 50% towards the future aspects, future prospects. So the 50% is the 90,000 to be added towards the future prospects. So yearly dependence comes to 2,70,000. Considering the age of the deceased at the time of accident to be 35. The applicable multiplier is 16. What is the date of birth?
Tribunal rightly considers 35 years.
Okay, 16. So after multiplying the multiplier,
37 years.
Page 34.
34.
28 as on 1/1/2005. Then also I will go with the
37 years.
yes, last 37.
37 years.
Yes.
Total 37 years. Applicable multiplier would be 15.
15.
15 is 16. 15. After adopting the multiplier, the award comes to rupees 40,50,000. 40,50,000. The claimants are the wife and the yes. Supply. You supply? You take it.
Yes.
The claimants are the wife and the minor children of the deceased. So they are entitled to get the general damages according to the direction of the Honorable Apex 14. Considering the same, the first in chronicity. So the after adding the same, the award comes to rupees 41,20,000. 41,20,000. Ladies and gentlemen, happen to the direction of the to past synchronicity. So after stop after adding the said general damages, the award comes to rupees 41,20,000. Stop. The payments has already received.
After receipt receipt from the by the goods order.
An amount of rupees 9,71,000. They have already received 9,71,331.99 paisa. Stop. 99 paisa. Other amount of my ball 41 lakh. Minus 9 lakh. Nine. Okay. You've already received the amount of. So the insurance company is directed to pay the balance amount of rupees 31,48,000. 668.01 paisa. Rounded up to rupees 31,48,600. 680. 668 along with 6% interest per annum to the claimants. To the claimants. 600 to the claimants. 6% interest per annum from the rate of filing of this application. To the office of the land registration within 8 weeks from the date of passing of this one. Stop on such deposit, the payments are reverted to report the same. To receive the same. To receive the same. There you are. To receive the same. According to the prevailing rules, subject to the payment of the requisite court fees. Subject to payment of requisite court fees. Subject to ascertainment of payment of requisite. Yes. The copy of CD. Copy of CD. be taken on the record. The payment is first, along with the calculations.
Lordship has considered 20,000 monthly income
Yes.
and future prospect 40%.
50%.
50%.
Okay.
Just one thing academically, Lordship, I just want to know, Lordship, my lord has dismissed his cross, and my lord has, so his cross doesn't remain.
No,
So Lordship has enhanced,
only on the basis of pronunciation.
yes, enhanced on my appeal.
Yes. Because for just and proper compensation.
My lord has added for this
Yes.
line for just and
Yes.
we'll hand over the this calculation
Yes.
in a while.
Okay.
Alida.